This is the brief on Philippine civil status and child protection laws. Philippine law throws a massive, fiercely protected legal shield around your identity from the literal day you're born until you marry, and anyone who messes with it faces devastating penalties. First, your birth. Faking a pregnancy or swapping out a baby to defraud heirs is a serious crime called simulation of births. Think of civil status as your legal DNA, right? Counterfeiting it is just as serious as identity theft. There's a 10-year amnesty under RA 11222 to fix simulated births, but literally only if it's truly in the child's best interest. Second, your youth. The prohibition of child marriage strictly outlaws unions involving anyone under 18. So do only the parents take the fall here? No way. Anyone facilitating pays at least 40,000 pesos. Public officers who solemnize it face a 50,000 peso fine, actual prison time, and getting fired. Finally, adulthood. Marrying again before your first marriage is legally dissolved is bigamy. But here's the 2021 Polito precedent. If your first marriage was totally void from the start, you actually don't need a judicial declaration to use that as a defense. Adulthood laws also guard against exploitation. The Anti-Mail Order Spouse Act guarantees 15 years mandatory prison for matching Filipinos to foreigners for profit. Wait, does that make Tinder illegal? Relax, the law expressly excludes legitimate dating sites. Ultimately, from your birth certificate to your marriage license, Philippine law wraps your legal identity in a lifetime security detail to guard against fraud and exploitation. So before anyone tries to rewrite a family tree, they better be ready for the legal avalanche.
Title 12 of the revised Penal Code focuses entirely on a specific category of offenses, crimes against the civil status of persons. Civil status is the public station, rights, and duties that determine a person's legal class. In Philippine law, this is strictly isolated to two defining pillars, filiation and marital ties. The state treats these pillars as matters of absolute public interest. A person's civil status is not a private right that can be freely negotiated, altered, or discarded. This matrix maps Title 12 statutory protections from inception to maturity. The foundation begins with falsification of origins. Article 347 criminalizes birth simulation, child substitution, and abandonment. The structure then moves to the corruption of legal unions, mapping Articles 349 to 352, which penalize bigamy. Through these statutes, the state constructs a contiguous protective web spanning from the moment of birth to the formation of a marriage. And this web is constantly updated by special penal laws and Supreme Court doctrine. The legal integrity of the state itself relies entirely on the authenticated origins and lineage of its citizens. If civil status is compromised, the entire system of inheritance, rights, and obligations collapses. Looking at Article 347, simulation of births requires a specific set of statutory elements. The offender must explicitly pretend to be pregnant, and on the supposed date of delivery, take the child of another. The law punishes the introduction of a stranger into a family and the resulting fraud against legitimate heirs. That same article also covers the concealment or abandonment of a legitimate child, but it hinges entirely on the offender's intent to cause the loss of that child's civil status. This requires distinguishing Article 347 from the abandonment of a minor under Article 276. Under Article 276, a mother abandons a child simply to avoid the obligation of rearing them. Under Article 347, the abandonment is calculated to erase civil status, for instance, to prevent the child from sharing in an inheritance. Therefore, leaving a newborn at the door of a hospital or religious institution so they might survive does not automatically constitute Article 347 abandonment. The prosecution must prove the specific intent to destroy the traces of filiation. While the Penal Code applies severe punitive measures to birth simulation, the legislature recognized that strict application sometimes harms the individuals it intends to protect. As shown in the matrix, RA 11222 creates a 10-year rectification moratorium. It provides an amnesty that suspends criminal liability for individuals who simulated a birth record. This amnesty operates under rigid requirements: the simulation predating the law, the child treated as their own, and an administrative adoption petition filed. Most importantly, the amnesty is only granted if the simulation was genuinely made for the best interest of the child. The state willingly suspends its strict punitive mandate when administrative truth-telling serves the higher legal standard of the child's actual welfare. Just as the law rigorously controls the establishment of filiation, it dictates strict thresholds for marital unions. This section illustrates RA 11596, the Prohibition of Child Marriage Act, establishing an age floor of 18. This repeals the Muslim code, which permitted girls to marry at 12. Facilitating child marriage is now a public crime. Offenders face substantial fines. If parents or guardians act as the facilitators, they permanently lose their parental authority. The law explicitly removes familial privilege as a shield for exploitation. That principle extends to the commercial exploitation of civil status, strictly governed by Republic Act No. 10906, the Anti-Mail Order Spouse Act. The statute prohibits any business scheme matching Filipinos to foreign nationals for marriage for profit. Penalties reflect the severity. Operators face 15 years of mandatory imprisonment, escalating to 20 years and a 5 million peso fine for syndicates. There is only one legal carve-out: legitimate dating websites designed to connect individuals based on shared personal interests are excluded, provided they are completely divorced from commercial marriage brokering. The Philippine state has eliminated cultural, religious, and commercial exceptions. Any union formed below the age of 18 or sold for profit is structurally void and criminally liable. The final layer in the defense of civil status is Article 349, bigamy. The baseline elements are straightforward. An offender is legally married and contracts a second or subsequent marriage before the former is legally dissolved, or before the absent spouse is declared presumptively dead. Historically, this created a massive prosecutorial tension. If a defendant's first marriage was legally defective, did they need a prior judicial declaration of nullity before using it as a defense against bigamy? In 2021, the Supreme Court resolved this in Polito v. People, clarifying Article 40 of the Family Code. It established a precise legal test based on the first marriage's nature. The first branch applies to voidable marriages. A voidable marriage is legally valid and subsisting until officially annulled. Therefore, the accused cannot interpose a late annulment decree as a retroactive defense. Because the marriage was valid when the second vows were spoken, bigamy is consummated. The second branch addresses void ab initio marriages, void from the beginning. The Polito Doctrine establishes an accused can collaterally attack a void ab initio marriage within the bigamy prosecution. The defendant doesn't need a prior declaration of nullity. If they prove the first marriage never existed, the charge fails. But the Supreme Court enforces strict boundaries on these defenses, as demonstrated in the Malaki v. People exception regarding religious conversion. In this scenario, a party bound by a subsisting civil marriage converts to Islam and subsequently contracts a second marriage under the Muslim code, arguing that Islamic law permits multiple wives in this scenario. The court ruled that conversion to Islam does not operate ex post facto to exculpate the individual. The jurisprudence is clear. The court relaxes the procedural burden for defendants with genuinely void origins, but fiercely closes loopholes for those attempting to use religious conversion to escape valid civil bonds. Evaluating this matrix, the architecture of Philippine civil status law comes into full focus. Crimes against civil status, from birth simulation under Article 347 to solemnizing a child marriage, operate as part of a singular, unified shield. These laws function together as a unified defense of the legal taxonomy of the Philippine citizen. Special penal laws modernize this shield. Measures like the RA 11222 amnesty and the RA 10906 trafficking prohibitions align the 1930s revised penal code with modern child welfare and exploitation standards. Jurisprudence provides the necessary precision. Decisions like Polito and Malaki ensure that bigamy convictions rely on substantive legal reality rather than procedural technicalities. For legal practitioners, Title 12 demands an integrated approach, treating the revised penal code, special laws, and the family code as interlocking mechanisms.
This video covers Title 12, Chapter 1 of Criminal Law 2, focusing on crimes against the civil status of persons. Specifically, we'll examine the simulation of births, substitution of one child for another, and the concealment or abandonment of a legitimate child under Article 347 of the Revised Penal Code. Article 347 addresses the simulation of births. The offender pretends to be pregnant and, upon the supposed date of delivery, takes another person's child. This act introduces a stranger into the family and defrauds legitimate heirs. A key element of simulation is the alteration of the child's status. It's a crime because it changes a person's civil status. The simulation is still a crime, even if the child is seemingly benefited, as the law punishes the creation of a false status detrimental to family members. Persons criminally liable for simulation of births are the woman simulating the birth and the person furnishing the child. Article 347 also covers the substitution of one child for another, which requires two children from different parents, a substitution to be made, and the intent to cause the loss of any trace of filiation. The third act punished under Article 347 is concealing or abandoning a legitimate child with the intent to cause the child to lose its civil status. This presupposes a fully developed and living legitimate child who is concealed or abandoned by the offender. Note that the unlawful sale of a child where the father agrees never to claim the child again is not considered abandonment under Article 347. The meaning of abandon here is linked to the historical practice of leaving newborn infants at the door of charitable or religious institutions for protection. The abandonment of a legitimate child under Article 347 is distinguished from abandoning a minor under Article 276. Under Article 347, the purpose is specifically to cause the child to lose its civil status, while Article 276 focuses on avoiding the obligation of rearing and caring for a child. A woman who abandons a child to free herself from the duty of care commits the crime of abandoning a minor under Article 276. If the abandonment is to preserve the inheritance of other children, it falls under Article 347. Abandoning a child in a way that suggests an attempt against its life may constitute attempted infanticide. Republic Act No. 7610 penalizes child trafficking, which includes acts like buying and selling children. The Act also penalizes attempts to commit child trafficking, such as a pregnant mother executing an affidavit of consent for adoption for a consideration, or recruiting people to bear children for trafficking purposes. Other acts penalized as attempted child trafficking under RA No. 7610 include simulation of birth by medical personnel or others for the purpose of child trafficking, and engaging in the act of finding children among low-income families or institutions who can be offered for child trafficking. The Domestic Adoption Act of 1998 defined and penalized the crime of simulation of births, including attempts. The penalties were in addition to those imposed by other laws. However, Section 62 of Republic Act No. 11642 has expressly repealed Republic Act No. 8552. The Domestic Adoption Act of 1998 initially provided a 5-year moratorium for the criminal prosecution of simulation of birth under specific conditions, primarily to serve the best interest of the child and correct birth registration. Republic Act No. 11222 provided a new 10-year moratorium, similar to the repealed Section 22 of RA 8552, for the rectification of simulated births. Note that RA No. 11642 subsequently repealed RA No. 8552. The Inter-Country Adoption Act of 1995 defines and penalizes illegal adoption and its syndicated form as child trafficking, punishable with reclusion perpetua. Section 62 of Republic Act No. 11642 amended RA No. 8042 to the extent that it was inconsistent with it. Criminal liability for simulation of birth may be extinguished by rectification and administrative adoption under the conditions prescribed by Republic Act No. 11222, otherwise known as the Simulated Birth Rectification Act. The Inter-Country Adoption Act of 1995 also defines and penalizes the crime of illegal adoption. The Simulated Birth Rectification Act, or Republic Act No. 11222, grants a 10-year moratorium for the criminal prosecution of simulation of birth offenses under specific conditions, and extends these benefits even to adult adoptees. Penal provisions of Republic Act No. 11642 impose imprisonment and fines for violations, including obtaining consent for adoption through coercion or fraud, non-compliance with adoption procedures, or exposing the child to danger, abuse, or exploitation. Any person causing the fictitious registration of a child's birth under the name of a non-biological parent is guilty of simulation of birth, facing imprisonment from 8 to 10 years and a fine not exceeding P50,000. Medical personnel who cooperate in this crime will suffer the same penalties and permanent disqualification from practice. Simulation of birth record involves tampering with the civil registry to falsify a child's parentage, causing loss of the child's true identity. If committed by a syndicate and involving a child, it is considered child trafficking, with penalties of 20 to 40 years of imprisonment. Syndicate acts are committed by a group of 3 or more persons conspiring to carry out the unlawful acts. Foreign national offenders will be immediately deported and perpetually denied entry after serving their sentence. Government officials or employees found guilty of violating the act or conspiring with private individuals shall be penalized and automatically suspended upon case filing. Adoption discrimination acts are also prohibited and penalized with fines. We now move to the crime of usurpation of civil status, covered by Article 348 of the Revised Penal Code. This includes penalties for the offense, with heavier penalties imposed when the purpose is to defraud the offended party or their heirs. The elements of usurpation of civil status require the offender to usurp the civil status of another, meaning representing oneself as another and assuming their filiation, parental, or conjugal rights. Civil status includes a person's public station, rights, duties, capacities, and incapacities, even one's profession. The second essential element is the intent to enjoy the rights arising from the civil status of another. Without this intent, the act may constitute a different crime, such as using a fictitious name or estafa, depending on the circumstances. This video covers Title 12, Chapter 2 of the Revised Penal Code, focusing on crimes against the civil status of persons, specifically illegal marriages, starting with bigamy under Article 349. We will examine the penalty and the elements of the offense. The first element is that the offender had been legally married, and their first marriage must be valid. The Supreme Court clarified that a judicial declaration of absolute nullity of a void ab initio marriage is not required as a defense in a bigamy case. However, if the first marriage is merely voidable, the accused cannot use an annulment decree as a defense, since the voidable marriage is considered valid and subsisting when the second marriage was contracted. Previously, nullity of marriage without judicial declaration was not a defense in a bigamy charge, but recent law expressly allows absolute nullity of a previous marriage to be invoked for remarriage only with a final judgment of nullity. Furthermore, a subsequent marriage while a previous one subsists is null and void unless the prior spouse was absent for the required number of years. It is now a more liberal view that a void ab initio marriage can be used as a defense in bigamy without a separate judicial declaration of absolute nullity. The accused can present evidence of absolute nullity. This view aligns with the retroactive effects of a void ab initio marriage and the purpose of Article 40 of the Family Code. We now look at void marriages under Articles 35 to 38 of the Family Code. These include marriages contracted by persons under 18 years old, marriages solemnized by unauthorized persons, and those solemnized without a license, unless of exceptional character. Further void marriages include bigamous or polygamous marriages not falling under Article 41, and marriages contracted through mistake of identity. Also included are subsequent void marriages under Article 53, marriages where a party was psychologically incapacitated, and marriages between ascendants or descendants of any degree. Other void marriages include those between siblings of full or half-blood, collateral blood relatives up to the 4th civil degree, step-parents and stepchildren, parents-in-law and children-in-law, and adopting parent and adopted child. The list of void marriages also encompasses those between the surviving spouse of an adopting parent and the adopted child, an adopted child and the legitimate child of the adopter, and adopted children of the same adopter. Finally, marriages are void if one party killed the other person's spouse or their own with the intention to marry the other. Next, we cover voidable marriages under Articles 41 and 45 of the Family Code. These include marriages where the party in whose behalf annulment is sought was 18 or over but below 21, and the marriage was solemnized without parental consent. Voidable marriages also include those where either party was of unsound mind, unless they freely cohabited upon regaining reason. Also included are marriages where consent was obtained by fraud or by force, intimidation, or undue influence, unless the injured party freely cohabited afterwards. Other voidable marriages include those where either party was incapable of consummating the marriage, and this incapacity is incurable, or afflicted with a serious and incurable sexually transmissible disease. Finally, marriages contracted by a person whose spouse has been absent for 4 consecutive years and declared presumptively dead in a summary proceeding are voidable. The second spouse is not necessarily liable for bigamy, as the offender is the one who contracted the subsequent marriage. However, the second spouse who knew of the first marriage can be considered an accomplice in bigamy. A witness who falsely vouched for a contracting party's capacity, knowing they were already married, is an accomplice in bigamy. Conversely, a witness merely attesting to the ceremony without vouching for the personal condition of the parties is not liable. The second element of bigamy is that the first marriage has not been legally dissolved, or the absent spouse cannot yet be presumed dead. The absence of legal dissolution of the first marriage is key. The death of a contracting party during the pendency of a bigamy case does not extinguish the crime. Causes for legal dissolution of the first marriage include the death of one of the parties and a judicial decree annulling avoidable marriage. Other causes for legal dissolution include a judicial declaration annulling avoidable marriage and divorce validly obtained abroad by an alien spouse. In the latter case, the Filipino spouse becomes capacitated to remarry under Philippine law, avoiding the absurd situation of remaining married to a person no longer their spouse. However, with the exception of divorce obtained abroad by an alien spouse, divorce granted by foreign courts to Filipinos does not bar prosecution for bigamy, especially if the cause is not recognized by Philippine laws. The rule applies even if the marriage was contracted elsewhere, but Philippine courts have no jurisdiction if the second marriage was contracted outside the Philippines. Divorce under the Code of Muslim Personal Laws severs the marriage bond, allowing spouses to contract another marriage. This rule applies even if only the male party is Muslim, provided the marriage adheres to Muslim law. Divorce according to customs of other cultural communities is not recognized, as divorce must be granted by a court with jurisdiction. The Supreme Court has ruled that a party to a civil marriage who converts to Islam and contracts another marriage, despite the first marriage's subsistence, is guilty of bigamy. Conversion to Islam does not exempt them from criminal liability. A married Muslim man may only marry another in exceptional cases, and the wife's knowledge is a formal requisite. If a Muslim male was married under the Muslim code or Muslim law before the code's effectivity and subsequently remarries, they shall not be indicted for bigamy, as per Article 180 of the Muslim Code. However, the general rule is that a married Muslim cannot remarry, with exceptions requiring just treatment as enjoined by Islamic law. The Muslim husband must notify the Sharia circuit court of his intent for a subsequent marriage. The court clerk must serve a copy to the wife or wives. If there is an objection, the Agama Arbitration Council hears the wife, and the Sharia court decides. The wife's knowledge is essential. Failure to comply with the statutory requirements under the Muslim code is punishable by arresto mayor or a fine. Cases like Nolora, Ong, and Saison all affirmed bigamy convictions, despite defenses invoking Article 180 of the Muslim Code. The Supreme Court maintains that a Muslim man who knowingly contracts a subsequent marriage without complying with the conditions of the Muslim Code is not exempt from bigamy liability. In cases of voidable marriages, the defense bears the burden of proving the legal dissolution of the first marriage. The prosecution only needs to prove the existence of the previous marriage at the time the second was contracted. The defense must prove the first marriage's dissolution by death or legal process before the second marriage. The absence of a judicial declaration of presumptive death, as required by Article 41 of the Family Code, is another key factor. Contracting a subsequent marriage before the requisite period for presumptive death, or without a judicial declaration, constitutes bigamy. The third element of bigamy is that the offender contracts a second or subsequent marriage. Subsequent marriages are allowed under the Code of Muslim Personal Laws, but the revised Penal Code provisions on bigamy are not applicable to persons married under Muslim laws, provided they follow the subsequent marriage requirements. The fourth element is that the offender's second or subsequent marriage has all the essential requisites for validity. These requisites include legal capacity of the contracting parties, free consent, an authorized solemnizing officer, a valid marriage license, and a proper marriage ceremony. The validity of the second marriage is a prejudicial question to bigamy liability. A final judgment of annulment of the second marriage, such as on the ground of duress, precludes a verdict of guilt in the bigamy charge, as it is determinative of the accused's guilt. Bigamy is a public offense, not a private crime, meaning it can be prosecuted by anyone, and not just the affected parties. The second wife's knowledge of the accused's first marriage is not a defense, as the offense is against the state. Bigamy is distinct from concubinage, as bigamy is against civil status and concubinage is against chastity. Bigamy is characterized by the celebration of a second marriage, while concubinage involves mere cohabitation. A person convicted of bigamy may still be prosecuted for concubinage. We continue with Title 12, Crimes Against the Civil Status of Persons, focusing on Chapter 2, Illegal Marriages. We first cover marriage contracted against provisions of law detailed in Article 350 of the Revised Penal Code. This includes the elements of the crime, such as the offender contracting the marriage and knowing the law's requirements were not met. The requisites for valid marriages include the legal capacity of the contracting parties, meaning they must be male and female. Other requisites are consent freely given in the presence of a solemnizing officer, and the officer must be authorized to solemnize the marriage. Further requisites include a valid marriage license, with exceptions for marriages of exceptional character. Also required is a marriage ceremony where the contracting parties appear before the solemnizing officer, mutually declare acceptance as husband and wife, witnessed by at least 2 people of legal age. The discussion covers marriages contracted in disregard of a legal impediment, such as a relationship between an uncle and niece. It also addresses marriages contracted by persons 18 and above but below 21 without parental consent, which are considered valid, but may still lead to criminal prosecution for contracting marriage against provisions of law. An Offenders Act under Article 350 may not constitute bigamy, such as when a second marriage is performed without a valid license on the basis of a falsified contract. Lastly, a conviction under Article 350 of the Revised Penal Code is considered to involve moral turpitude. Article 351 concerning premature marriages has been repealed by RA number 10,655. However, the Code of Muslim Personal Laws continues to penalize marriages before the expiration of iddah, a variable waiting period for women whose marriages have been dissolved by death or divorce. We move on to the performance of illegal marriage under Article 352 of the Revised Penal Code. The penalty includes imprisonment and a fine. The elements require the offender to be a priest, minister of any religious denomination, or a civil authority authorized to solemnize marriages. If the offender performs or authorizes an illegal marriage ceremony and is not authorized to solemnize marriages, they may be liable under Article 177 for usurpation of authority. The Code of Muslim Personal Laws also penalizes illegal solemnization of marriages. We now examine the Anti-Mail Order Spouse Act, Republic Act No. 10,906, which repealed the previous Representative Act No. 6,955. The act declares unlawful the practice of matching Filipino women for marriage to foreigners on a mail order basis and similar practices. The objective is to protect Filipino women from exploitation. Representative Act No. 6,955, now repealed by Representative Act No. 10,906, declared unlawful the practice of matching Filipino women for marriage to foreign nationals, including advertising, publishing, or distributing propaganda materials. The law's policy is to protect Filipino women from exploitation. The penalty under the former Representative Act No. 6,955 included imprisonment and a fine, with deportation and perpetual prohibition to re-enter the Philippines for foreign offenders. The law clarified that its provision should not restrict freedom of expression or association for purposes not contrary to law. Acts punished under the former Representative Act, No. 6,955, include establishing or carrying on a business for matching Filipino women to foreign nationals. It also prohibits advertising, publishing, printing, or distributing propaganda to promote such matching practices. The prohibited acts also include soliciting or inducing any Filipino woman to join a club or association whose objective is marriage matching. Additionally, using postal service to promote this practice is unlawful, as is allowing or consenting to this matching practice by media entities. Persons liable for the unlawful practices include individuals, natural or juridical, associations, clubs, or other entities. If the offender is an entity, criminal sanctions are imposed upon incumbent officers who knowingly participated in the violation. Section 3 of the Anti-Mail Order Spouse Act, RA 10906, details the prohibited acts. These include engaging in any scheme for profit to match or offer a Filipino to a foreign national for marriage or common law partnership, including through online means. It also prohibits exhibiting or distributing promotional materials or uploading them online. The law also prohibits soliciting or inducing any Filipino to become a member of any club or association whose objective is to match Filipino nationals to foreign nationals for a fee, and using the internet to promote these prohibited acts. However, Legitimate dating websites are not covered by this act. Section 4 outlines the penalties for violations of the Anti-Mail Order Spouse Act, including imprisonment for 15 years and a fine ranging from 500,000 to 1 million pesos. Abettors or cooperators face the same penalty. If the act is committed by a syndicate or on a large scale, the penalty is 20 years imprisonment and a fine of 2 to 5 million pesos. Next, we examine Republic Act No. 11,596, which prohibits and criminalizes child marriage, defining a child as any person under 18 years of age. Child marriage is defined as any civil, church, or customary marriage where one or both parties are under 18. It is unlawful to facilitate, arrange, or solemnize child marriage. The penalties under RA 11,596 vary based on the role of the offender. Facilitators and arrangers face fines and prison terms. Parents or guardians who facilitate child marriage face stiffer penalties and loss of parental authority. Solemnizing officers face fines, imprisonment, and dismissal if they are public officers. Cohabitation by an adult with a child also leads to prison and fines. Prior to RA 11,596, the Muslim Code on Personal Status allowed girls as young as 12, if they reached puberty, and boys at 15 to marry. RA 11,596 effectively repeals this, raising the minimum age to 18 for all. This video examines the Philippine penal frameworks on civil status, filiation, and illegal marriages, which are critical for safeguarding individual identity and the institution of marriage. Our reference framework includes the revised Penal Code, specifically Title 12, and intersecting special laws such as RA 11596, RA 7610, RA 11222, and RA 11642. The penal laws focus on three main pillars: protecting the vulnerable, preserving truth in filiation, and upholding the institution of marriage. The unifying thread is that the law severely punishes the falsification of reality, including simulation of birth, usurpation of identity, or the illusion of a valid marriage. RA 11,596 established the absolute prohibition of child marriage. This law defines child marriage as any union involving a party under 18. It represents a major paradigm shift by universally setting the minimum age at 18, effectively repealing previous exceptions like those in the Muslim Code. Liability for facilitating child marriage escalates depending on the role. Facilitators and arrangers face a fine and imprisonment. Parents and guardians face higher fines, longer imprisonment, and loss of parental authority. Solemnizing officers face the highest penalties, including perpetual disqualification from public service. Article 347 of the revised Penal Code addresses crimes against filiation, focusing on altering reality. These crimes include simulation of birth, substitution of a child, and concealment or abandonment of a child, all of which aim to permanently alter a child's civil status or defraud legitimate heirs. The specific intent behind child abandonment determines the charge. Abandoning a minor to avoid the obligation of rearing is charged differently than an intent to sever civil rights, which falls under crime against civil status. The most severe intent, to cause death, is charged as attempted infanticide. Simulation of births is classified into two distinct legal tracks. Syndicated aggravation under RA 7610 and RA 11642 escalates the crime to child trafficking, punishable by reclusion perpetua. In contrast, RA 11222 introduced a 10-year rectification moratorium, which extinguishes criminal liability if certain conditions are met. Usurpation of civil status, under Article 348, involves representing oneself as another person to assume their familial or conjugal rights. The critical distinction is the absolute necessity of intent to enjoy the rights from the usurped status. Without this intent, the act may be classified as estafa, or using a fictitious name. Bigamy, defined in Article 349, requires 4 elements: a prior valid marriage, no legal dissolution of that first marriage, contracting a subsequent marriage, and the second marriage possessing all essential requisites for validity if the first did not exist. The Bigamy Defense Diagnostic Matrix differentiates between void ab initio and voidable first marriages. A void ab initio first marriage can be used as a valid defense in a bigamy case. However, a voidable first marriage is considered valid and subsisting and cannot be used as a defense. The Muslim Code provides a procedural exception for a married Muslim to marry another, but requires fulfilling strict requisites. Furthermore, The Malaki doctrine establishes the conversion trap. Converting to Islam does not retroactively exculpate a person from a prior civil marriage, and a subsequent marriage would still constitute bigamy. Marriages against the law cover two primary offenses. Article 350 penalizes the contracting party who disregards legal requirements, which often involves moral turpitude. Article 352 penalizes the solemnizing officer for performing illegal marriage ceremonies. If the officer is unauthorized, the crime shifts to usurpation of authority. Combating commodification under RA 6955 and RA 10906 prohibits marriage matching schemes for profit. Prohibited acts include engaging in schemes, advertising, soliciting members, and using websites to promote these acts. Legitimate dating websites are explicitly excluded from this prohibition. The penalties landscape demonstrates escalating liability. Level 1 involves illegal solemnization. Level 2 covers bigamy and child marriage facilitation. Level 3 includes anti-mail order spouse violations. Level 4, the maximum, applies to syndicated simulation of births or child trafficking, punishable by reclusion perpetua. The Philippine penal framework creates an unbroken shield for a citizen's civil status from birth to grave. It protects identity by penalizing fraudulent creation of status and safeguards the marital institution from deceit and transactional exploitation, securing the foundational truth of human connection.
Okay, let's dive right into this. Welcome to The Explainer. Today, we're exploring something that's absolutely fundamental to all of us, the legal foundation of literally who we are. Think about it. The law protects our identity, our family ties, and our marital status. But what exactly happens when someone decides to manipulate those facts? Well, we're looking at crimes against civil status, uncovering exactly how the law guards the very pillars of our identity. So you gotta ask yourself, what is your civil status actually worth? It might seem like just a routine checkbox on a government form, right? But legally speaking, the stakes are incredibly high. Tampering with this foundation plunges us into a fascinating kind of true crime adjacent world of simulated pregnancies, stolen identities, and marital fraud. It's a world where lying about who you are or who you're married to carries some seriously severe consequences. Here's our roadmap for today. We'll be looking at faking births and identities, stealing a civil status, the complexities of bigamy when marriages are void, and illegal matchmaking and marriages. Let's get right to it. Section 1. Faking births and identities. We're starting at the very beginning of a person's legal existence. First, let's anchor ourselves a bit. What exactly do we mean by a civil status? It's the public station, rights, duties, capacities, and incapacities which determine persons of a given class. Simply put, it dictates your right to inherit property, your duties as a parent, and your overall legal capacity in society. It is the DNA of your legal existence. Now, what's really wild here is how the law actually defines the simulation of birth. We're not just talking about a simple lie to your neighbors. Under Article 347 of the Revised Penal Code, this is a major crime. It involves a woman pretending to be pregnant, taking another person's child on the supposed delivery date, and introducing a stranger into the family. The ultimate damage here? It completely alters a child's legal status and effectively defrauds the legitimate heirs out of their rightful inheritances. But hey, the law isn't totally heartless when it comes to the messy realities of families. Take a look at this number, 10. The Simulated Birth Rectification Act actually provides a 10-year moratorium. This offers a much-needed amnesty period to fix simulated births. Provided the simulation was committed prior to the law, the child was consistently treated as a son or daughter, and, most importantly, it was done in the best interest of the child. It's a structured legal path to rectify past wrongs out of love without anyone facing prison time. And, this perfectly illustrates just how deeply intent matters in criminal law. Think about the physical act itself. It's exactly the same, abandoning a baby. But consider these three distinct scenarios. If you leave a baby at a hospital door specifically to cause the loss of their civil status, say, so they can't claim an inheritance, that is abandonment under Article 347. If you leave them just to avoid the obligation of raising them, it's abandoning a minor under Article 276. But if you leave a baby in a lonely forest where it might die of exposure, that escalates all the way up to attempted infanticide. Exact same physical act, three entirely different crimes based purely on what was going on in the offender's head.
Section 2. Stealing a civil status.
Okay, so we've talked about manipulating the status of babies, right? But what happens when you steal the legal status of an adult who already exists? This brings us to usurpation of civil status under Article 348. The absolutely crucial point here is that usurpation isn't just about stealing a name or pretending to be someone's spouse. The legal definition of civil status actually includes a person's profession. That means if you petition for the issuance of another person's professional license, assuming their person and their profession, you are committing usurpation. You are literally stealing their livelihood and their public station.
Moving on to Section 3, the complexities of bigamy.
Welcome to the highly dramatic and honestly super messy world of illegal marriages. This is where the legal web gets incredibly dense. For a bigamy charge to actually stick, 4 very specific things have to happen. First, the offender was legally married. Second, that first marriage has not been legally dissolved. Third, they contract a subsequent marriage. And fourth, and this is the vital one, that second marriage has all the essential requisites for validity, meaning the second marriage would have been perfectly legally valid if not for the pesky little fact that the first one still existed. If the second marriage was missing a marriage license anyway, well, it's a completely different crime, not bigamy. Now, people mix up bigamy and concubinage all the time, but there's a really clear distinction here. Bigamy is an offense against civil status. It's prosecuted by the state, and the crime is the actual celebration of that second marriage. Concubinage, on the other hand, is an offense against chastity. It's prosecuted by the offended spouse and is characterized by mere cohabitation. Because they are distinct in fact and in law, a person convicted of bigamy can actually still be prosecuted for concubinage right after. You absolutely do not get a 2-for-1 deal here.
Section 4, when marriages are void. All right, prepare yourselves because we're introducing a massive plot twist in Philippine law. Check out this landmark 2021 Supreme Court ruling from Pulido versus People. It is time to abandon the earlier precedents. A void ab initio marriage can be used as a defense in bigamy, even without a separate judicial declaration of absolute nullity. The Supreme Court literally flipped the script. It used to be that you absolutely needed a judge's paper to prove your first marriage was void before you could defend yourself against a bigamy charge. Not anymore.
Let's break down exactly what that means. If your first marriage was void ab initio, which literally means it never legally existed from the start, like say it was between a brother and sister, you can use that as a defense in bigamy without needing a judge to declare it void beforehand. But on the flip side, if your first marriage was voidable, meaning it's considered totally valid until it's actively annulled by a court, like if consent was obtained by fraud, you cannot use it as a defense without that prior annulment decree. In that specific case, the crime of bigamy is already consummated. We also have to look at a strict procedural exception under the Code of Muslim Personal Laws. Even there, the general rule is that a married Muslim man cannot just unilaterally decide to marry someone else. In exceptional cases where he can prove equal companionship, he has to follow these exact steps. He must first notify the Sharia Circuit Court. The clerk then serves a copy to the current wife. If she objects, an Agama arbitration council is formed to hear her out. And finally, the court makes the decision. The wife's knowledge is absolutely essential here. You just cannot bypass this legal process. And finally, Section 5, illegal matchmaking and marriages. For our last pillar, we're focusing on how the law actively protects citizens from being exploited by illegal marriage businesses. This all falls under the Anti-Mail Order Spouse Act. The law steps right in to prevent the commodification and exploitation of Filipinos, particularly women. It strictly prohibits engaging in a business that matches Filipinos to foreigners for a fee. It bans advertising these services, soliciting members for mail-order marriage clubs, and even using the postal service or the internet to promote these acts. The penalties here are super severe, which really reflects the law's commitment to human dignity. But hold on, don't panic. I do want to point out a crucial, very modern legal caveat here. Legitimate dating websites meant to cultivate personal dating relationships are absolutely not covered by this act. So yes, reassuringly, swiping right on your favorite dating app isn't going to land you in prison for illegal matchmaking. The law is targeting exploitative, profit-driven matching businesses, not modern romance. Which brings us to our final thought. If the law goes to such incredible lengths to protect the foundations of your birth, your professional identity, and your marriage, well, how well are you guarding your own civil status? It truly is the DNA of your legal life. Thank you so much for joining me on this explainer. I really hope this structured journey helped you grasp these legal pillars. Keep asking questions and stay curious.
Consider the absurdity of penalizing someone based on a foundation that does not exist. It is impossible to build a subsequent legal reality on top of a structure that was never there from the beginning. Yet this exact scenario plays out in the Philippine justice system under Article 349 of the Revised Penal Code, which defines and punishes the crime of bigamy. The core trigger of the crime is straightforward: contracting a second or subsequent marriage before the former marriage has been legally dissolved. But this poses a contradiction. How does the state treat a second marriage if the first marriage was void ab initio, meaning under the law it never existed in the first place? This contradiction created a rigid trap. For decades, individuals went to prison for violating a marriage bond that the state itself acknowledged was legally impossible. Historically, Philippine courts maintained a strict stance. A citizen could not simply decide their first marriage was defective and move on. They needed a formal judicial declaration. Even if a first marriage was blatantly illegal from day one, remarrying without this paper guaranteed a bigamy conviction. In 2021, the Supreme Court issued a ruling in Polito v. People. The court explicitly abandoned those earlier precedents, acknowledging the structural flaw in the old system. The Polito decision altered defense strategies by decoupling the civil administrative requirements of the Family Code from the strict criminal liability defined in the Revised Penal Code. This logic matrix outlines the 4 strict elements the prosecution must prove to secure a conviction under Article 349. The first element acts as the bedrock. The offender must have been legally married. The second element requires that this first marriage has not been legally dissolved, or in the case of an absent spouse, they cannot yet be legally presumed dead. The third element requires the offender to contract a subsequent marriage, and the fourth requires that this subsequent marriage possesses all essential legal requisites for validity. Because the final 3 elements are largely matters of public record, signed contracts and marriage certificates, a criminal trial almost always hinges on the structural integrity of the first element. The Family Code splits defective marriages into void and voidable. Void marriages lack essential requisites from the start, like marriages without a license, incest, or psychological incapacity. Voidable marriages possess essential requisites, but suffer from defects like fraud, force, or lack of parental consent. The operational difference is critical. A voidable marriage is considered 100% legally valid and subsisting until the exact moment a judge formally annuls it. This creates a trap. If one marries a second time inside an unannulled voidable marriage, the crime of bigamy is consummated the second the vows are exchanged. Obtaining an annulment decree for the first marriage after the second marriage has already occurred is entirely useless as a criminal defense. At the time of the second ceremony, the first marriage was still legally binding. For voidable marriages, the chronological timing of the second marriage dictates absolute criminal guilt, regardless of any civil court corrections made later. Article 40 of the Family Code dictates that the absolute nullity of a previous marriage may be invoked for purposes of remarriage only on the basis of a final judgment. Older jurisprudence, particularly cases like Weigel v. Sempio D., ported this purely civil requirement over to criminal law. This forced criminal defendants into an impossible position. They had to pause a criminal trial to fight a lengthy civil battle, simply to prove they shouldn't go to jail for a marriage that was always void. The Polito ruling directly addressed this friction, stating, Article 40 of the Family Code did not amend Article 349 of the Revised Penal Code. The court reasoned that Article 40 outlines the administrative rules for obtaining a new marriage license. It does not erase a citizen's right to defend themselves in a penal proceeding. The defense now has a specific procedural weapon, the collateral attack. An accused individual can present documentary or testimonial evidence proving the absolute nullity of their first marriage directly to the criminal judge. They completely bypass the need for a prior civil decree. This restores the proper burden of proof. The prosecution must prove beyond a reasonable doubt that the first marriage was actually valid before they can strip a citizen of their liberty. There are boundary conditions to these defenses, notably involving the Code of Muslim Personal Laws, or Presidential Decree No. 1083. Islamic law allows a male Muslim, in exceptional cases, to contract subsequent marriages if he can deal with them with equal companionship and just treatment. However, the Supreme Court established strict limits in Malaki and Salanatin Malaki versus People. This case dealt with individuals converting to Islam after already being civilly married. The court ruled that converting to Islam does not exculpate a person from criminal liability regarding a prior subsisting civil marriage. Furthermore, even for Muslims, there are strict statutory requirements. A husband must notify the Sharia Circuit Court of his intent, and the Agama Arbitration Council must be constituted to hear the wife before a subsequent marriage is valid. Religious conversion cannot be weaponized as a retroactive legal loophole. The state's interest in the original civil contract remains supreme. This flowchart maps the current legal architecture for defending against a bigamy charge, depending on the status of the first marriage. For avoidable marriages, the timeline is rigid. The defense must produce a civil annulment decree that is dated prior to the celebration of the second marriage. For void ab initio marriages, the defense can introduce evidence of absolute nullity concurrently, right inside the criminal trial itself. The prosecution cannot rely on mere presumptions of validity. They carry the ultimate burden to prove the indisputable legal existence of the prior marriage. This modern framework correctly aligns criminal guilt with actual legal capacity, ensuring citizens are not jailed for phantom marriages. Bigamy falls under Title 12 of the Revised Penal Code, Crimes Against the Civil Status of Persons. The state prosecutes these crimes aggressively, even if no individual spouse claims to be materially or physically harmed, because the offense is an attack on the institution of marriage itself. But the Pulido Doctrine has a strict limit. While a collateral attack acts as a shield against a prison sentence, it does not cure the civil illegality of the second marriage. Merely avoiding a criminal conviction does not automatically grant you civil legal rights or a valid marriage license.
Imagine you are 35 years old, right? You've built a life.
Yeah, you have a career, maybe a family of your own, a mortgage.
Exactly. And then one day, you're just looking through a family safety deposit box and you discover a discrepancy.
Oh, wow.
Yeah, a piece of paper that basically unravels your entire existence. You find out that the birth certificate you have used your whole life is a complete forgery.
The one that got you enrolled in school, secured your passport, everything.
Right. The one that allowed you to inherit from your grandparents. And the loving parents who raised you, who, kissed your scraped knees and sent you to college, they actually committed a severe state crime to get you.
Just completely shatters the foundation of who you understand yourself to be.
Yeah.
Right? Both legally and personally.
Yeah, it really does.
You suddenly occupy this incredibly precarious space where your legal identity is it's a fiction.
And that is the exact dramatic reality we are unpacking today. So welcome to the deep dive.
Glad to be here.
For you, the curious learner listening right now, our mission today is to explore a legal landscape that sounds terribly bureaucratic on paper, but is remarkably explosive in practice.
It really is.
We are examining the Philippine laws surrounding civil status, child protection, and marriage. And to do this, we're analyzing a few sources, right?
Yes, a really comprehensive academic syllabus on criminal law 2 by Lorenzo U. Padilla, plus excerpts from the Prohibition of Child Marriage Act, which is Republic Act number 11596, and a detailed legal infographic.
Which is awesome. And I have to say, while civil status sounds like, boring paperwork, these laws actually cover some of the most dramatic human stories imaginable.
Oh, absolutely.
We're talking faked pregnancies, switched babies, secret second marriages, and mail-order spouse syndicates.
It's intense stuff, and the central theme we're going to uncover across all these materials is that your civil status isn't just a matter of checking a box on a tax form. In the Philippines, it is a rigorously protected public institution. It dictates your rights, your inheritance, and your identity literally from birth to death.
Okay, let's unpack this. Because right from the start, we need to define what civil status actually means in the eyes of the law.
Yeah, specifically looking at how it's fiercely protected under Articles 347 and 348 of the Revised Penal Code.
Right. So before we get into the theatrical crimes of faked pregnancies and secret marriages, what exactly is the state protecting here? What is civil status?
Well, to understand the severity of the crimes, you really have to understand what is being stolen or manipulated.
Okay.
Civil status isn't merely your given name or your marital designation. Legally speaking, it encompasses your public station, your inherent rights, your civic duties.
Wow.
Yeah, your legal capacities and your incapacities. It determines precisely what class of persons you belong to in the eyes of the state.
Which then dictates how you interact with the world.
Exactly. And it even extends to your professional licensure.
Wait, let's pause on that. My profession is considered part of my civil status.
Yes. Under Article 348, which governs the usurpation of civil status, assuming someone else's identity isn't just about draining their bank account.
Right, because that would just be categorized as fraud or estifa, right?
Precisely. But if someone petitions for the issuance of another person's professional license to practice as an engineer or a physician, they are actively usurping civil status.
Oh, wow. So it's not just like, I am pretending to be you to steal your money. It's, I am legally occupying your space in society to exercise your specific state-granted civic rights.
That is the crucial distinction right there. The legal materials highlight that intent is everything here.
Okay.
To be convicted of usurpation under Article 348, the offender must demonstrate the specific intent to enjoy the rights arising from the civil status of another.
So if an individual uses a fake name simply to hide from a creditor,
that might just be a violation of using a fictitious name. If they do it solely for immediate monetary gain, it's fraud. But usurpation is the act of stepping into the actual legal shoes of another human being.
and the law elevates the penalties significantly if the purpose of this impersonation is to defraud the offended party or their rightful heirs, doesn't it?
Yes, absolutely. It's heavily penalized.
And, you know, the concept of defrauding heirs brings us to one of the most theatrical parts of the legal literature we're examining.
Article 347.
Yes. The simulation of births and the substitution of one child for another. I mean, when you read the exact choreography required to commit this crime, it sounds like a plot of a 19th century novel.
It really does feel like a piece of historical fiction. But it addresses a very real legal vulnerability.
Right.
Article 347 punishes the creation of a false civil status from the very moment of birth.
Because the ultimate goal of the offender here is to cause the loss of traces of a child's true filiation, right?
Exactly. Meaning their biological and legal parentage. And to fraudulently acquire another status to which that child has absolutely no right.
So the legal texts break down the specific elements of this crime, and the required sequence of events is just, it's highly specific.
Very.
First, the offender has to actively pretend to be pregnant.
Yeah.
Second, on the date of the supposed delivery, they take the infant of another person.
Right.
And third, the status of that taken child is officially altered. I mean, they are effectively introducing a complete stranger into a family bloodline.
And the legal commentary we're reviewing points out that the primary motive behind this elaborate deception is almost entirely financial.
Wow, really?
Yeah. It is designed to defraud legitimate heirs. Imagine a scenario involving a vast family estate.
Okay.
A woman fakes a pregnancy, quietly procures a newborn from someone outside the family, and then presents the infant to her wealthy husband as his legitimate biological heir.
Oh my gosh. In a single act, she has systematically stolen the future inheritance from any other rightful children, siblings, or extended relatives.
It is the ultimate heist.
Yeah. Instead of breaking into a vault to steal the gold, you are manufacturing a human heir to legally route the gold directly to yourself.
Exactly. But there is a detail in the legal text that I found utterly fascinating.
What's that?
The commentary explicitly states that it is not a valid legal defense if the child actually benefits from the deception.
Wait, really? That is a fundamental legal principle that really reveals how the state prioritizes systemic integrity over individual circumstance.
Yes.
Think about the defense argument you could mount. An offender could say, well, I took this baby from a situation of extreme poverty.
Right.
I brought them into a home with immense wealth, private education, a massive trust fund. I drastically improved their life.
But the state says, no, you still committed a profound crime.
Why is the law so uncompromising on this point? Like, why doesn't the better life matter?
Because the state is protecting the macro institution of the family and the absolute integrity of the civil registry, not the micro-level material comfort of the infant.
Oh,
The legal authorities cited in our sources emphasize that the law punishes the creation of a false status specifically because of the detriment it causes to the existing members of the family into which the child is introduced.
Because you are legally forcing a family to accept a stranger.
Yes. To share their ancestral name and eventually to divide their estate with someone who has no biological or legal standing to be there.
The injury is inflicted upon the public record and the legitimate family structure.
Exactly.
That structural logic makes sense. I mean, if someone corrupts the core database of a society, the fact that they moved a corrupted file into a very nice folder doesn't change the fact that the database is compromised.
Right. A corrupted file is a corrupted file.
And this intense focus on internal motive and intent leads us to an incredibly complex area of the law.
The legal distinctions surrounding the abandonment of a child.
Yes, this part is wild.
The scenarios involving abandonment serve as a masterclass in how criminal law dissects human intention. The physical action is identical, but the legal consequences vary wildly based on the state of mind.
Okay, before we break down those scenarios, we need to decode some of the penal language used in these texts.
Good, yeah.
The materials frequently reference terms like prison mayor and reclusion temporal. For someone unfamiliar with the Philippine penal system, what are we actually talking about in terms of real-world consequences?
It is essential context. The Philippine penal system utilizes a graduated scale of punishment that reflects the historical development of its laws.
Okay.
When the texts mention prison mayor, we are looking at a prison sentence that generally ranges from 6 years and 1 day up to 12 years.
Oh, wow. Up to 12 years.
Yes. And importantly, this isn't just about physical confinement. It carries accessory penalties, such as the temporary absolute disqualification from holding certain public offices or exercising the right to vote.
So it's a loss of liberty coupled with a loss of civic participation.
Correct. And then the severity escalates to reclusion temporal, which spans from 12 years and 1 day up to 20 years.
20 years.
And for the most heinous crimes, the law prescribes reclusion perpetua, stretching from 20 to 40 years.
Okay, so understanding these tiers is vital because it shows exactly how heavily the state weighs the severity of altering a civil status versus other crimes.
Yeah.
With that context, let's examine the abandonment scenarios, because it's kind of like a video game branching storyline. The concept in criminal law relies on the intersection of the actus reus, the guilty physical act, and the mens rea, the guilty mind.
Yes, the mind is key.
Now let's look at the first branch. A mother gives birth and leaves the infant in a certain place simply to free herself from the obligation, the financial burden, and the daily duty of rearing the child.
The law classifies that specific act as abandoning a minor, falling under Article 276 of the Revised Penal Code.
Okay.
The offender must be someone who has custody of the child, and their driving purpose is merely avoiding the responsibility of parenthood.
Now let's take the second branch. The physical act is exactly the same, leaving the infant, but the internal motive shifts completely. A woman gives birth to a legitimate child, but she abandons the baby specifically to preserve the inheritance of her older children from a former marriage. She isn't just tired, she actively wants this new baby erased from the legal bloodline.
That shift in motive escalates the crime entirely. It moves from mere abandonment of a minor to the concealment or abandonment of a legitimate child under Article 347.
Because her evident purpose is to cause the child to lose its civil status so it cannot legally share in the inheritance.
Precisely. And the historical context provided in our text notes that this law was originally crafted to address a well-known practice during the Spanish colonial era of leaving newborn infants at the doors of hospitals, churches, or convents.
The legal presumption there is fascinating. I mean, by leaving a healthy newborn wrapped in blankets on the steps of a church, you aren't trying to harm the baby. You expect someone to find it and raise it.
Exactly. You don't want the child to die. You simply want to erase its connection to you. You are actively severing the civil traces of filiation.
So the first scenario is essentially, I am running away from the work, while the second scenario is, I am surgically removing this child from my legal history.
Yes, that's a perfect way to put it.
But then there is a third branch. The mother gives birth and abandons the baby in the middle of a remote, isolated forest, miles away from any human settlement.
The legal commentary cites actual case law for this scenario, and the shift in intent here is severe.
Right.
By leaving an infant in a lonely, desolate place where it is highly unlikely to be discovered, the Offenders Act goes beyond erasing a legal record. It constitutes a direct attempt against the life of the child.
Wow. Even if, like, a hunter happens to stumble upon the baby and saves it.
Yes. Even then, the charge isn't just abandonment to lose civil status. The state views the intent as attempted infanticide.
Because you put them somewhere they would likely die. And there is a fourth scenario that introduces an entirely different legislative framework.
What's that?
What if a father decides to unload the responsibility of a child by selling the infant to a stranger, explicitly agreeing never to claim the child again?
Ah, yes.
You might assume that because he physically abandoned the child and the child lost its civil connection to him, it falls under the same civil status crimes.
You would assume so, but the Supreme Court, in landmark rulings like U.S. versus Capillo, drew a sharp distinction.
Really?
Selling a child does not constitute abandonment under Article 347. Abandonment under that specific article fundamentally requires leaving a child in a place where others may find and take charge of it.
Because selling a human being is an entirely different mechanism of exploitation.
Exactly.
So how does the modern legal system handle that?
Today, that act is aggressively prosecuted under Republic Act No. 7610, the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act.
Oh.
It is classified as child trafficking. Engaging in the trading of children, buying or selling them for money, or any form of consideration, carries massive penalties, often reclusion temporal to reclusion perpetua. Wow. It is a stunning illustration of how the justice system operates. The exact same physical entity, a baby being given away, can result in a minor abandonment charge, a civil status crime, an attempted murder charge, or a functional life sentence for human trafficking. It relies entirely on the location chosen and the specific thought process in the parent's head at the time of the act.
It highlights the immense burden placed on investigators and prosecutors, right, to prove not just what happened, but exactly why it happened.
Definitely. It's incredibly difficult to prove state of mind.
So we have been discussing the simulation of birth and the altering of civil status as these malicious, highly calculated plots driven by greed or a desire to traffic human life.
Right.
But the legal history reveals a much more complicated sociological reality. Here's where it gets really interesting. A massive number of these crimes in the Philippines were not committed by criminal syndicates or greedy heirs.
No, you weren't.
They were committed from a place of genuine love.
This is the deeply complex phenomenon of illegal informal adoption.
Desperate families, perhaps a couple struggling with infertility, taking a child from an overwhelmed young mother, or a relative living in extreme poverty.
Which happens a lot.
Yeah, but instead of navigating the lengthy, highly bureaucratic, and often expensive legal adoption process, they just take a shortcut.
Right. They pay a local midwife or a civil registrar to simply put the adoptive parents' names on the newborn's birth certificate as the biological parents.
It's an instant, paper-perfect family.
Administratively, it feels like a victimless quick fix.
Yeah, I mean, everyone is happy, right?
Legally, however, it is the exact crime of simulation of birth that we just explored. You are willfully tampering with the civil registry, manufacturing a fictitious registration, and causing the permanent loss of the true biological identity of the child.
Wow.
Under modern frameworks like the Domestic Administrative Adoption and Alternative Child Care Act, causing this fictitious registration carries severe prison terms.
And what about the doctors or midwives who help?
If a medical professional, a doctor, nurse, or midwife, facilitates this in violation of their professional oath, they face imprisonment and the permanent revocation of their license to practice.
But practically speaking, the state eventually recognized that throwing tens of thousands of well-meaning, loving adoptive parents into prison mayor wasn't serving anyone.
Least of all the children who would be ripped away from the only homes they had ever known.
The state faced a profound conflict between the strict enforcement of the penal code and the sociological reality of how non-traditional families were being formed.
Right, because in family law, the absolute guiding star is always the best interest of the child.
Tearing a teenager away from their loving parents because of a falsified document created 15 years prior directly contradicts that interest.
So the legislature created a legal escape hatch to reconcile this. A moratorium.
Oh, fascinating.
It was an evolution of policy. The initial attempt was the Domestic Adoption Act of 1998, which offered a 5-year amnesty. But the more robust and current mechanism detailed in our sources is the Simulated Birth Rectification Act, RA 11222.
RA 11222.
Yes. This law provided a new 10-year moratorium, a formal suspension of criminal prosecution for the specific act of simulating a birth.
It is vital to note, though, that this is not a blanket amnesty where anyone can just walk away from the crime.
No, not at all.
The state attached incredibly specific, non-negotiable conditions. First, the simulation of the birth had to be committed prior to the effectivity of the law. You cannot forge a birth certificate tomorrow and then try to claim amnesty under this act.
Right. Second, the initial act must have been motivated by the best interests of the child, not financial fraud.
Okay, that makes sense.
Third, the child must have been consistently treated, loved, and raised as a true daughter or son by the purported parents.
And the fourth condition is the procedural cure. The parents must actively rectify the public record.
Yes. They have to file a formal petition for adoption coupled with an application for the correction of the simulated birth record within the 10-year window.
If a family successfully meets all these stringent conditions, the state extinguishes all criminal, civil, and administrative liability. The slate is entirely wiped clean.
Which is a huge relief for so many families.
What I found truly remarkable about this legislative approach is its compassion regarding time.
Yes.
The legal texts explicitly note that the benefits of RA 11912 extend to adult adoptees. Consider what that means. A person could be 35 years old, married with their own children, and suddenly discovered that their birth certificate was falsified by their parents back in the 1990s.
Happens more often than you'd think.
Under this law, they can still utilize this process to legally rectify their civil status without the terror of sending their elderly parents to a federal penitentiary.
It is a rare and beautiful example of the law adapting to protect the psychological and emotional reality of a family, prioritizing human connection over the rigid sanctity of the paper trail.
It really is.
And to further cement the protection of that psychological reality, the newest child care laws strictly prohibit what they define as adoption discrimination.
Which is a massive cultural shift. The legal materials point out that acts like labeling, shaming, bullying, or creating any negative stigma around a child because of their adopted status are now actively penalized by the state with significant fines.
Up to 20,000 pesos, actually. It represents a complete philosophical pivot.
Yeah.
The state has moved from aggressively hunting down and punishing the paper crime of the parents to aggressively protecting the dignity and emotional well-being of the adopted child.
So, if we look at the trajectory of these laws, a clear logic emerges. The state goes to extreme, uncompromising lengths to protect the paper trail of a child's identity at birth. It will even forgive a felony to protect a child's emotional security.
Right.
So, it stands to reason that the state would be equally fierce about protecting the physical and developmental sanctuary of the child's life as they grow up.
That logical progression brings us to one of the most absolute, unyielding boundaries drawn in modern Philippine jurisprudence.
Which is?
The Prohibition of Child Marriage Act, Republic Act number 11596.
This law, signed into effect in late 2021 and implemented in 2022, represents a monumental shift.
A huge one.
It establishes a universal, uncompromising definition across the archipelago. A child is any person under 18 years of age, and the marriage of a child is absolutely, unequivocally prohibited.
The language of the law leaves no room for interpretation. It applies universally to every form of union.
Every form.
Yes, whether it is a civil ceremony officiated by a judge, a religious church wedding, or traditional and customary unions practiced by indigenous groups.
Wow.
It even extends to informal cohabitation. If an adult is living with a minor outside of wedlock in a marriage-like arrangement, the state treats it with the exact same severity.
There are zero exceptions for cultural practices. This is where the sociological impact of the law truly hits the ground. Our sources highlight a staggering reality. This new law effectively repealed long-standing sections of the Code of Muslim Personal Laws.
That is the critical friction point. Prior to RA 11196, the Muslim Code allowed for specific conditional exceptions.
Right.
Under that framework, girls as young as 12, provided they had reached puberty, and boys at the age of 15 were legally permitted to marry under Islamic law.
Moving the legal threshold from 12 up to 18 overnight is not just a legal amendment. It is an attempt to rewrite generations of deeply ingrained cultural and religious tradition.
It's massive.
How does a state actually implement a law that directly contradicts the established practices of a massive portion of its population?
Well, you cannot enforce a cultural earthquake overnight without risking massive societal backlash.
Right, that would be chaotic.
The legislature understood this and built in transitional mechanisms. RA 11196 included a specific one-year transition period targeted at Muslim Filipinos and indigenous communities.
Okay, so what did that transition period look like?
During that 12-month window, the penal provisions, the massive fines, and the prison sentences were suspended for those specific groups.
So it wasn't an immediate threat of prison, but a mandated period of adjustment.
Exactly. It was a grace period designed for extensive, on-the-ground education and dialogue. The law mandated that agencies like the Department of Social Welfare and Development, the Department of Health, and the Department of Education use that year to build protective infrastructure.
Engage with religious leaders, explain the public health rationale behind ending child marriage.
Yes. However, the law was clear. Once that transition year expired, the penal provisions applied fully, equally, and without exception to every single citizen of the Republic.
Let's examine those penal provisions because they reflect the state's absolute zero-tolerance policy. If an individual acts as a facilitator or an arranger, the person who negotiates or fixes the child marriage, they face a minimum fine of 40,000 pesos.
And a prison term.
Right, a prison term of prison mayor in its medium period, which, as we discussed, means roughly 8 to 10 years behind bars.
It's severe.
If a public officer or religious leader solemnizes the wedding, the fine increases to at least 50,000 pesos, significant prison time, and permanent dismissal from public service.
But the architecture of the law reserves the most devastating penalties for the parents or guardians who facilitate or consent to the marriage of their underage child.
This is where I want to play devil's advocate and really challenge the state's logic.
Okay, go for it.
Under this law, parents face a minimum 50,000 peso fine, the maximum period of prison mayor up to 12 years in prison, and the absolute permanent loss of their parental authority.
They are legally severed from their child.
Now, theoretically, consider a family living in crushing, desperate poverty. They might genuinely, if misguidedly, believe that marrying their daughter to an older, wealthier man is the only way to ensure she doesn't starve.
Right.
Does permanently destroying the family unit by stripping parental authority seem excessively draconian in that context? I mean, completely removing the parents from the equation.
It is a profound sociological tension, and the scenario you described is the reality for many who engage in this practice.
Yeah.
However, the state's philosophical stance in RA 11496 is unyielding. The law operates on the principle that parental authority is not an inherent, untouchable right of the adult.
Okay, what is it then?
It is a sacred trust granted by the state specifically for the protection and benefit of the child.
So the state is basically saying, we gave you this authority to protect them and you used it to sell them.
Precisely. When a parent facilitates a child marriage, regardless of their internal rationalization regarding poverty or tradition, the state views it as a fundamental betrayal of that trust.
I see.
The law inherently defines child marriage as an act of child abuse and commodification. When a parent becomes the instrument of that abuse, the state argues it has a moral and legal imperative to revoke the authority it granted.
Because you cannot leave a child in the legal custody of the person who just attempted to sell their childhood.
Exactly. The DSWD, the Department of Social Welfare and Development, has to step in as the ultimate guardian.
The state stops treating the parent as a struggling guardian and starts treating them as an active threat to the citizen.
Yes.
And this uncompromising stance is reinforced by how the law classifies the crime itself. RA 11496 designates child marriage as a public crime. What does that distinction mean in the machinery of the justice system?
The distinction between a private and public crime alters who holds the power to initiate justice.
Okay.
In many private crimes, such as adultery or concubinage, the state will not intervene unless the specific offended party files a formal complaint.
So the victim holds the key to prosecution.
Right. But because child marriage is classified as a public crime, the power to prosecute is democratized.
So theoretically, a neighbor could trigger a state prosecution.
Absolutely. A teacher who notices a student has dropped out, a concerned neighbor, a distant relative, or an NGO worker can report the marriage. The state will immediately step in and prosecute the parents and facilitators vigorously, regardless of whether the terrified child or the coerced parents want to press charges.
That is a staggering exertion of state power. The state is essentially saying, the victim here isn't just the individual child. The victim is the society we are trying to build. And if the parents fail catastrophically, we will step in.
It is the ultimate expression of the state protecting civil status. They fiercely protect your identity at birth, and they fiercely protect your physical sanctuary until you are 18.
But once you cross that threshold, once you turn 18, become a legal adult, and are legally free to marry you, step out of the sanctuary and into a labyrinth.
Oh, absolutely.
The legal maze surrounding adult marriage is incredibly dense, and the most tangled part of that web is what happens when you attempt to marry again.
This brings us to a complex, historically rich area of jurisprudence. The laws surrounding illegal marriages, primarily focusing on bigamy under Article 349 of the revised Penal Code.
Bigamy is one of those crimes that exists in the popular imagination, right?
Yeah. All right, everyone thinks they know what it is.
Everyone assumes they understand it. A person being married to two different people at the same time. It's the classic trope of the man with a secret second family across town.
Right.
But the legal materials reveal that bigamy is far more structural than simple infidelity. To understand it, we need to compare it to another crime you mentioned earlier, concubinage.
Yes.
Because the law draws a razor-sharp philosophical line between the two.
It is a critical distinction that goes back to what we discussed about private versus public crimes. Concubinage essentially involves a husband maintaining a mistress in the conjugal dwelling, cohabiting with her elsewhere, or having sexual relations under scandalous circumstances.
Okay.
The law categorizes this as an offense against chastity. It is a private crime. The state will only prosecute it at the direct instance of the offended wife.
If the wife decides to look the other way, the state looks the other way. But bigamy is entirely different.
Bigamy is classified as a public offense against civil status. It is an attack on the integrity of the state's registry.
Wow.
Therefore, it is prosecuted at the instance of the state itself. The academic commentary highlights case law, affirming that it is entirely immaterial whether the first spouse or the second spouse initiates the criminal complaint.
So a civic-spirited citizen who happens to uncover the dual marriages can denounce the offender, and the state will aggressively pursue the conviction.
Yes.
That means the state treats the existence of two marriage certificates not as a private betrayal, but as a public hazard.
And there is a terrifying reality for the offender here. The materials note that a person convicted of bigamy can simultaneously be prosecuted for concubinage.
Oh, wow. Both at the same time.
They're not mutually exclusive because they punish different acts. Bigamy is consummated by the mere celebration of the second marriage ceremony, while the first legally exists.
You commit the crime the moment you sign the contract, even if you never live with the second spouse.
Right. Concubinage is characterized by the physical act of cohabitation or scandalous relations. Because they are distinct, in fact, in law and in the mode of execution, an offender can serve time for both.
To truly grasp the danger of bigamy, we need to untangle its legal elements. On the surface, the elements seem straightforward.
Right.
First, you had been legally married. Second, that marriage has not been legally dissolved by death or annulment. Third, you contract a second marriage.
Okay.
And fourth, that second marriage has all the essential requisites for validity, meaning it would have been perfectly legal if you weren't already married.
That is the textbook definition. Yeah. However, the true complexity and the source of decades of fierce legal battles lies entirely in the status of that first marriage.
Right.
The core question is, what if your first marriage was technically illegal or flawed from the very beginning?
This is where we dive into the dense, confusing web of void versus voidable marriages. This concept is the engine behind almost all bigamy defense strategies.
Let's hear it.
Let's test an analogy here to see if it clarifies the distinction. Imagine a legal contract. A void marriage is like a contract written in invisible ink. You might have stood at an altar, you might have had a ceremony, and you might have even signed a piece of paper. But in the eyes of the law, there's absolutely nothing on the page. It never existed.
Like that.
A voidable marriage, on the other hand, is a contract written in permanent ink, but it contains a massive typo.
Right.
It is fully binding, legal, and enforceable upon both parties from the moment it is signed, and it remains valid until one of the parties actively takes it to a judge, points at the typo, and asks the court to formally cancel the contract.
That analogy perfectly captures the legal philosophy. A void marriage is void ab initio. It is void from the very beginning. It produces zero civil effects.
Okay.
A voidable marriage is valid and subsisting until the exact moment a competent court formally annuls it.
Let's look at the specific legal categories for both, because understanding the invisible ink versus the typo is literally a matter of prison or freedom. Give us examples of marriages written in invisible ink.
Under the family code, a marriage is void from the start if it was contracted by any person below 18 years of age.
As we covered earlier.
Exactly. Even if the parents consented, the state says it never happened. A marriage is void if it was solemnized by someone who possessed no legal authority to do so, unless the couple believed in good faith that the person had authority.
Okay.
It is fundamentally void if there was no valid marriage license issued prior to the ceremony.
Makes sense.
It is also void if it is incestuous, meaning marriages between ascendants and descendants, brothers and sisters, and collateral blood relatives up to the fourth civil degree.
Right.
The state also voids marriages between step-parents and step-children, or parents-in-law and children-in-law.
In all those cases, the law refuses to recognize that a civil status was ever created. Now, what about the contracts with the bad typo? The voidable marriages.
A marriage is voidable under Article 45 of the Family Code if, for example, a party was 18 or over, but below 21, and they married without the required consent of their parents or guardians.
So it's legal, but
The marriage is legally valid. But the parents, or the party themselves, upon turning 21, have a specific window of time to petition the court to annul it.
got it. What else?
A marriage is also voidable if either party was of unsound mind at the time of the ceremony, or if their consent was obtained through fraud, force, intimidation, or undue influence.
Wow. Okay.
Furthermore, it is voidable if either party was physically incapable of consummating the marriage and the condition appears incurable, or if either party was afflicted with a serious, incurable, sexually transmissible disease.
Let's look at the implications of that. If someone holds a gun to your head and forces you to sign a marriage contract, common sense would say that marriage is fake.
Right.
But under the law, because it was obtained by intimidation, it is merely voidable. It is legally valid until you manage to escape, hire a lawyer, get to a courtroom, and have a judge drop a gavel to annul it.
Exactly. Until that judicial decree is issued, you are legally bound by that civil status.
And this philosophical difference between invisible ink and a typo leads us directly to a monumental earthquake in Philippine jurisprudence.
Yes, the Polito case.
The legal texts heavily emphasize a landmark 2021 Supreme Court decision, Polito versus People. To understand why this case is so massive, we have to look at the dark ages before it.
Right.
Before 2021, how did you defend yourself against a bigamy charge if your first marriage was void?
Before Polito, the prevailing legal precedent was an absolute nightmare for defendants. Based on a strict interpretation of Article 40 of the Family Code, the courts ruled that an individual could never take the law into their own hands to determine if their marriage was void.
Oh no.
You always, without exception, needed a formal judicial declaration of nullity from a court before you could safely marry again.
So even if your first marriage was to your first cousin, which is undeniably void and written in invisible ink, you couldn't just walk away and marry someone else.
No. If you walked away and married someone else without first spending years in court getting a piece of paper that confirmed the invisible ink was invisible, the state would convict you of bigamy.
That is wild.
The lack of that prior judicial declaration was fatal to your defense.
That seems incredibly inefficient and punishing to citizens who are trapped in fake marriages.
It was heavily criticized for decades, which is why Polito versus People is a paradigm shift. The Supreme Court in 2021 finally abandoned those rigid earlier precedents.
So?
The court clarified that Article 40 of the Family Code, which requires the judicial declaration of nullity, is strictly a requirement for the administrative purpose of remarriage.
Okay.
It was never intended to amend the revised Penal Code to deny an accused person their fundamental right to mount a defense in a criminal trial.
So what does that practically mean for a person sitting in a courtroom on trial for bigamy today?
It means they're allowed to make a collateral attack on their first marriage during the criminal proceedings.
What's a collateral attack?
If your first marriage was void ab initio, truly invisible ink, you do not need to show the judge a prior annulment decree to avoid prison.
Oh, awesome.
During your bigamy trial, your defense attorney can simply present evidence, whether it is witness testimony or a certification of no marriage license from the civil registry, proving that the first marriage never legally existed.
Oh, I see.
If you successfully prove it was void from the start, the criminal court will recognize that there was no prior valid marriage to violate, and you will be acquitted of bigamy.
That ruling must have saved thousands of people from prison and years of pointless, expensive litigation.
Absolutely.
But UT, there is a massive flashing warning sign attached to this ruling in the legal literature.
A critical limitation.
If your first marriage was merely voidable, the contract with the typo, the Polito ruling, offers you absolutely zero protection.
Correct. Because a voidable marriage, as we established, is considered entirely valid and subsisting right up until the moment it is annulled by a court.
So if you don't get it annulled first...
Therefore, at the exact second you stand at the altar and say, "I do," to your second spouse, your first marriage is still legally alive, even if it was based on fraud or force.
Wow.
The crime of bigamy is instantly consummated. You cannot go back later, get the first marriage annulled, and then try to use that subsequent annulment as a defense to the crime you already committed.
That is a razor-thin legal tightrope. If a citizen assumes their first marriage was void, but a judge later decides it was actually voidable, they are going to prison.
It is an incredible risk to take without securing a court decree first.
Now, speaking of trying to dodge bigamy charges through legal technicalities, the academic materials detail a fascinating, highly controversial loophole attempt that the Supreme Court recently had to slam shut.
Ah, You were referring to the sophisticated defense strategy addressed in the Maliki and Salanant Maliki versus People case from late 2021.
Exactly. This is the classic maneuver of, I am legally trapped by the civil marriage laws, so I'm going to convert to a different religion to exploit their specific rules.
Yeah.
We saw individuals who were legally married under the standard civil law and unable to get an annulment, suddenly converting to Islam.
Right.
Their goal was to utilize the provisions of Islamic law to take a second wife without being prosecuted for bigamy.
It became a prevalent and deeply problematic defense strategy. It relied on a willful misinterpretation of the Code of Muslim Personal Laws, specifically Presidential Decree number 1083.
How did they argue it?
The defense counsel would stand before a civil judge and argue that because their client is now a practicing Muslim, and because Islamic law permits a man to have multiple wives under certain conditions, the state lacks the jurisdiction to indict him for bigamy under the revised penal code.
It's an attempt to change the rules of the game halfway through by changing your jersey. How did the Supreme Court dismantle this argument in the Maliki case?
The court systematically broke down the legal reality, establishing several critical barriers. First, they affirmed the fundamental principle that a subsequent religious conversion does not operate retroactively to exculpate a person from criminal liability regarding a subsisting civil marriage.
Meaning?
You cannot unilaterally sever a civil contract governed by state law merely by adopting a new faith.
The state's law supersedes the individual's religious pivot when it comes to prior civil contract.
Exactly. But the court went further. They clarified that even if we examine the situation purely under the lens of the Muslim code, the defense fails.
Why?
The popular misconception is that Islamic law provides a blank check for unlimited polygamy. The Supreme Court pointed out that under the Code of Muslim Personal Laws, a married Muslim man may take another wife only in exceptional cases.
Okay, what kind of exceptions?
The law explicitly mandates that he can only do so if he could deal with them with equal companionship and just treatment, as enjoined by Islamic law.
It is a conditional right, heavily burdened with ethical and practical obligations.
And crucially, it is burdened with incredibly strict statutory and procedural requirements. A man cannot just secretly marry a second woman.
Walk us through those procedural requirements, because the law clearly hates secrets when it comes to civil status.
The Muslim husband is legally required to first notify the Sharia Circuit Court, the specialized court handling Islamic personal law in the jurisdiction where his family resides, formally stating his intent to contract a subsequent marriage.
Okay.
The clerk of that court is then mandated to serve a copy of this notice to the current wife or wives.
So she has to know.
The law insists that the current wife's knowledge of the impending subsequent marriage is an absolute non-negotiable requisite. The academic commentary emphasizes that this requirement of knowledge cannot be waived under any circumstances.
She must be informed, and the court must be involved. What happens if the first wife receives this notice and objects? What if she says, he cannot provide equal companionship?
The Muslim code provides a mechanism for that exact scenario. If the wife objects, the law mandates the constitution of an Agama arbitration council.
What's that?
This is essentially a formal mediation and arbitration body deeply rooted in Islamic jurisprudence, designed to hear the wife's concerns and evaluate the husband's capacity to fulfill his obligations fairly.
Okay.
Ultimately, the Sharia Circuit Court weighs the council's findings and decides whether to sustain the wife's objection or allow the marriage.
So if a man legally married under civil law secretly converts to Islam, bypasses the Sharia court, hides his intent from his first wife, ignores the arbitration process, and marries a second woman, what happens?
The Supreme Court, citing a long line of precedents, including cases like Nalora, Ong, and Sayson, ruled that he has utterly failed to comply with the statutory requirements of the very religious code he is trying to hide behind.
Oh, wow.
Therefore, he cannot claim any exemption. The conviction for bigamy will stand. The state firmly declared that religion cannot be weaponized as a shield to defraud the civil status registry or to deceive a spouse.
It continually circles back to the state's absolute mandate to protect the integrity of the public record. And speaking of the people involved in creating that record, I found a detail regarding complicity to be completely wild. We naturally assume bigamy is a crime committed exclusively by the person standing at the altar getting married twice.
Right, the person getting married.
But the law casts a much wider net. You can end up in prison just for standing nearby and nodding your head.
We are entering the realm of accomplice liability.
Yes. The academic materials point out that a witness to a wedding who falsely vouches for the legal capacity of either of the contracting parties, fully knowing that the party is already legally married, is guilty as an accomplice to bigamy.
It's true.
Think about the implications of that. If your best friend is married and you stand up at his secret second wedding, sign the registry, and attest that he is single and free to marry, the state holds you criminally liable.
Because you are actively facilitating the corruption of the public record. And this accomplice liability extends significantly to the second spouse.
Wait, really? The second spouse?
Now, the second spouse is not automatically liable as a principal offender. The principal is the individual who is already married. However, if the second spouse had prior knowledge of the first marriage and still willingly and knowingly consented to proceed with the second ceremony, legal commentators like Viada assert they are guilty as an accomplice.
Wow.
The philosophical query posed in our legal texts is compelling. Since voluntary consent is the absolute indispensable foundation of any marriage, doesn't knowingly providing that consent to a fraudulent union constitute indispensable cooperation in the crime?
It is impossible to argue otherwise. The second spouse is a vital component in manufacturing the fraudulent status, and the law doesn't just target the couple and their friends. Articles 350 and 352 of the Penal Code aim directly at the solemnizing officers, the priests, the ministers, the mayors, and the judges who officiate the ceremonies.
Article 350 governs the crime of contracting marriage against provisions of laws. This applies when an individual contracts a marriage fully knowing that the strict administrative requirements of the law were not met.
So this is distinct from bigamy. This isn't about having two wives. This is about having an illegal wedding.
Exactly. The classic example is proceeding with a wedding without a validly issued marriage license.
Or, recalling our discussion on voidable marriages, if two 19-year-olds manage to convince a priest to marry them without presenting the legally required parental consent, they are actively violating Article 350.
Right. The legal literature cites Supreme Court cases where an individual was acquitted of bigamy because the second marriage was demonstrably void due to the lack of a valid license. But that same individual was simultaneously convicted under Article 350 because they knowingly contracted a marriage in blatant disregard of legal impediments.
And the consequences ripple outward. The texts note that a conviction under Article 350 involves moral turpitude.
Yes.
It cites real-world examples where individuals were permanently disqualified from being admitted to the Philippine bar, barred from ever becoming lawyers, simply because they were convicted of participating in an illegal wedding ceremony. The state views it as a fundamental failure of character.
And Article 352 brings the heavy hand of the state down on the authorities who perform these ceremonies.
What happens to them?
If a priest, minister, or civil authority who is legally authorized to solemnize marriages performs an illegal ceremony, say, marrying a couple without a license or marrying a minor, they face severe imprisonment and substantial fines under the provisions of the marriage law.
It is a comprehensive lockdown on the entire institution. The spouses, the best man, the parents, the priest. Every single participant is held criminally accountable for ensuring that the civil status being manufactured is legitimate, accurate, and legally sound.
There really is.
The state acts as this hyper-vigilant architect, constantly inspecting the foundation of society to ensure no one is utilizing substandard or fraudulent materials.
That architectural analogy is perfect. The traditional crimes we have dissected so far, the simulation of a birth, the facilitation of a child marriage, bigamy, the orchestration of illegal ceremonies, are all analog methods of manually manipulating that societal foundation.
Right, analog.
They involve forging a physical document, hiding a spouse across town, or bypassing a parent's physical consent. But while those remain prevalent, traditional crimes against the institution of marriage, the dawn of the digital age introduced an entirely new, highly efficient vector for manipulation.
The internet.
It allowed for the commercialization of civil status on a global scale.
Which provides the perfect transition to our final area of analysis. We are moving away from the analog deception of a faked birth certificate and stepping into the modern, borderless marketplace of human connection. Mail order spouses.
Yes.
We are examining Republic Act number 1906, the Anti-Mail Order Spouse Act.
To truly understand the necessity and severity of RA 1906, we must look at the legal and societal landscape it replaced.
Okay.
The academic texts note that the predecessor to this law was RA 6955, enacted back in 1990. The explicitly stated policy of that original law was to ensure the enjoyment of a decent standard of living and to fiercely protect Filipino women from exploitation, recognizing that their human dignity was being disregarded in their desperate pursuit of economic upliftment.
Because what was occurring in 1990 was visceral and physical. This was the era of literal, printed, mail-order catalogs.
Exactly. Physical brochures.
Organized syndicates were printing glossy brochures and flyers featuring the photographs and physical descriptions of Filipino citizens, almost exclusively women living in poverty, and mailing these catalogs internationally.
It's hard to believe it was that blatant.
They charged foreign men a subscription fee to browse the catalog and be matched with a woman for the explicit purpose of marriage.
It was the ultimate literal commodification of civil status. These syndicates were treating the profound legal and personal status of spouse as a consumer product to be packaged, marketed, and sold for corporate profit, directly exploiting the severe economic vulnerability of the citizens.
Wow.
RA 6955 criminalized that specific business model, imposing penalties of 6 to 8 years in prison.
But 1990 is a millennium ago in technological terms. That law was drafted before the internet was ubiquitous, before smartphones existed, and before social media connected the globe.
Right, the world changed.
Syndicates don't need to print physical brochures anymore. They can run sophisticated global websites reaching millions of men instantly. The law had to radically evolve to catch up with the technology. Enter RA 10906 in 2016.
RA 10906 represents a drastic broadening of the prohibited acts and a massive overhaul of the penal consequences.
What did it change?
It made it unlawful to engage in any business or scheme, whether for money, profit, or any material consideration, which has for its primary purpose the matching of a Filipino citizen to a foreign national for marriage or common law partnership.
And the language of the new law explicitly targets the new technology. It prohibits doing this on a traditional mail-order basis, but it also explicitly outlaws matching through personal introduction, email networks, or websites on the internet.
Yes.
It further criminalizes the act of advertising, publishing flyers, or soliciting Filipinos to join clubs or associations whose underlying objective is to match them with foreigners for a fee.
The penalties attached to the new law are staggering, accurately reflecting how intensely the state views the danger of this modern commodification. Under RA 1906, an individual found guilty faces a mandatory minimum imprisonment of 15 years and a fine of up to 1 million pesos.
15 years mandatory. That is an enormous escalation from the old 6-year penalty.
And the law escalates further to target the root of the problem: organized crime.
Oh, syndicates.
If the prohibited act is committed by a syndicate, which the law defines as 3 or more persons conspiring together, or if the operation is conducted on a large scale, the penalty jumps to 20 years imprisonment and a crushing fine of up to 5 million pesos.
Wow, 20 years.
Furthermore, if the offender operating the syndicate is a foreign national, the law mandates they be immediately deported after serving their 2-decade sentence and perpetually denied entry back into the country.
Now, as we dissect this, I have to introduce a very practical, modern question that I know the listener is formulating right now.
Pushishu.
You just stated that the law strictly prohibits using websites on the internet to match Filipinos with foreign nationals. What does this mean for the massive, ubiquitous dating apps like Tinder, Bumble, or OkCupid?
Right, the dating apps.
Millions of Filipino citizens use these platforms daily. If a user pays for a premium Tinder subscription to unlock a feature that allows them to swipe globally and potentially meet someone from another country, are they inadvertently funding an illegal international marriage syndicate?
That's a very valid concern.
Are the Silicon Valley CEOs of these dating apps facing 20 years in a Philippine penitentiary?
It is a vital, highly relevant question regarding how the law interacts with modern digital behavior. The drafters of RA 19906 anticipated this exact technological friction.
Oh, they did?
The law contains a very explicit and crucial exclusion clause. It states, "The above notwithstanding, legitimate dating websites, which have for their purpose connecting individuals with shared interests in order to cultivate personal and dating relationships, are not covered by this act."
Okay, that prevents a mass panic. But from a legal standpoint, what is the actual structural distinction there? How does a judge or a prosecutor look at a website interface and declare, this platform is legitimate dating, versus This platform is a criminal syndicate.
The legal differentiation relies entirely on the business intent, the revenue model, and the degree of user agency.
Okay, break that down for me.
A legitimate dating application provides a neutral digital infrastructure.
Right.
It connects independent individuals based on geographic proximity, shared interests, or algorithms, allowing them to communicate and cultivate a relationship organically at their own pace.
So it's just a tool.
Right. The platform generates revenue by charging for enhanced features, like seeing who liked your profile, or the ability to digitally browse in different cities, but the platform does not guarantee a marriage, nor does it act as an active broker or negotiator for a marriage.
So the app functions essentially as a massive digital coffee shop or bar where you can meet people. You pay for the coffee or the premium feature, but what happens after you say hello is entirely up to the two independent adults.
Precisely. The crime defined under the Anti-Mail Order Spouse Act occurs when the business entity itself acts as a broker.
Ah, a broker.
It is when the matching process is conducted specifically and explicitly with the intent of facilitating a marriage or common law partnership in exchange for profit or material consideration paid directly to the broker for that specific outcome.
I see the difference now.
In an illegal syndicate, the Filipino citizen is the underlying product being advertised, packaged, and delivered to the foreign client, who pays a procurement fee. In a legitimate dating app, the users are independent agents utilizing a communication tool. The state outlaws the brokering and selling of human beings, not the facilitation of digital communication.
It continually circles back to that fundamental concept. Commodification. The state absolutely refuses to allow its citizens and their profound legal capacity to enter into a marriage to be slapped with a price tag and sold on the international market by third-party profiteers.
Exactly.
It is a robust defense of human dignity woven directly into the defense of civil status.
It is.
Well, we have traversed a massive expanse of legal and sociological territory today. For you, the listener, let's take a moment to synthesize the journey we've just undertaken.
We've covered a lot.
We began at the absolute genesis of life, examining how intensely the penal code punishes the simulation of a birth or the strategic abandonment of a child to defraud an inheritance.
Great.
We saw how the law slowly evolved to provide a compassionate moratorium for families who simulated births out of desperation and love, prioritizing the child's reality over the paper trail. We then confronted the absolute legal boundary of 18, exploring how the Prohibition of Child Marriage Act universally defends childhood by stripping the rights of parents who attempt to facilitate early exploitative marriages.
Yes.
From that boundary, we navigated the incredibly complex labyrinth of adult marriage, untangling the severe consequences of bigamy, the critical distinction between void and voidable marriages under the paradigm-shifting Pulido precedent, and how the Supreme Court definitively closed the loophole of using religious conversion to hide a secret family.
And then the digital age.
Exactly. Finally analyzing how the law has desperately tried to keep pace with technology, fighting the digital commercialization of civil status through the Anti-Mail Order Spouse Act to protect citizens from being brokered as commodities on the internet.
If there is one overarching macro-level takeaway to extract from all of these diverse legal texts, it is this. The Philippine legal system views your civil status not as a private, isolated personal matter, but as a foundational public institution.
Yeah.
It is the architectural framework upon which the entire nation is built. To tamper with it, whether an individual is faking a pregnancy, marrying a minor, hiding a previous spouse behind the invisible ink of a void marriage, or brokering marriages for corporate profit, is not viewed as a mere administrative error or a private sin.
It's much bigger than that.
It is aggressively prosecuted as a direct attack on the integrity and the fabric of the state itself. The state demands absolute transparency, authenticity, and strict adherence to the rules it has established.
The state demands a clean, binary, perfect legal reality. It wants a system where every identity and relationship is verifiable and exact. But as we've seen throughout this deep dive, human nature is inherently messy.
Very messy.
People are driven by overwhelming greed, by crushing desperation, by centuries of tradition, and yes, sometimes by profound love to blur those rigid lines. We have seen how fiercely the law fights to keep the lines drawn and the records clear.
Indeed.
But I want to leave you, the listener, with a final provocative thought to mull over as we conclude our exploration today. We have spent this time examining how fiercely the law protects the paper trail, the physical documents that prove who we are, who our parents are, and who we are legally bound to.
Right.
But our lives, our relationships, and our very identities are moving increasingly and inevitably into the digital ether. We are entering an era dominated by artificial intelligence, a world where identities can be manufactured not with forged signatures and stolen hospital records, but with the generation of code.
That's a scary thought.
If a person can utilize AI today to create a flawless deepfake video, a perfect digital replica of a human being saying and doing things they never actually did, how long is it until someone attempts to digitally simulate an entire civil status tomorrow?
Wow.
When the fraud is no longer happening in the dusty archives of a local civil registry, but is being generated autonomously in the cloud, how will these incredibly rigid, paper-based laws adapt to protect the reality of who we are?
It's going to be a huge challenge.
It is a murky, fascinating frontier that the law will inevitably have to face. Thank you for joining us on this deep dive. We will catch you on the next one.
Welcome to the debate. Imagine facing up to 12 years in prison for marrying your current spouse, only to escape that terrifying criminal charge on what sounds like a mind-bending technicality.
Right, proving that your first marriage was actually a legal ghost.
Exactly. A union that, despite the wedding photos and the years lived together, legally never existed at all. Because when we think about the law, we often picture it as this massive, intricately designed piece of architecture.
That is the expectation, certainly. I mean, the legal structure is supposed to be binary. A wall is either load-bearing or it's not. You're either compliant with the code or you are in violation. It's the predictability of that structure that allows a society of millions to function without collapsing into total chaos.
But then you walk into the realm of family law and civil status, and suddenly that pristine skyscraper starts to look a lot more complicated. Because sometimes the blueprint says there's a solid foundation, but in reality, you're standing on thin air.
Right.
So today we are examining the Philippine legal framework surrounding crimes against the civil status of persons. Specifically, we're looking at the crime of bigamy under Article 349 of the Revised Penal Code and this absolute earthquake of a ruling from the 2021 Supreme Court case, Polito v. People.
Yeah, it really was an earthquake. And the central question we are wrestling with here is how the state protects civil status, which, is the foundation of public order. So does the Polito ruling, which allows an accused person to defend against a bigamy charge by proving their first marriage was void ab initio, meaning void from the very beginning?
Right, void from the beginning, without needing a prior judicial declaration. Does that ruling represent a triumph of logical statutory construction, or does it dangerously undermine the state's strict regulation of civil status by allowing individuals to just bypass formal judicial processes when it suits them?
Well, I will be arguing that Polito correctly aligns penal law with substantive reality. It protects citizens from unjust criminal prosecution over marriages that legally never existed in the first place. And I will be arguing that this ruling inappropriately shifts the burden of proof in a way that conflicts with the state's overarching framework. The state demands rigorous, formal processes to alter or confirm something as fundamental as civil status. And, Polito creates a perilous loophole in that system.
Let me lay out why Polito is such a crucial corrective in Philippine law. I see why you think that requiring a formal judicial declaration is necessary for state order. But let me give you a different perspective. Bigamy, under Article 349 of the Revised Penal Code, has a very specific first element.
The prior marriage.
Right. The offender must have been legally married. That is the foundational premise of the crime. If a marriage is void ab initio, meaning it lacked a valid marriage license, or, say, it was contracted between close blood relatives, then that foundational element of bigamy is entirely absent. The marriage is a legal phantom.
But the state's ledger doesn't just automatically update.
Hold on, allow me to finish this thought because it's vital for our listeners. Now, if you're listening to this, you might be thinking, wait, they had a wedding, they lived together, how is the marriage a phantom? The key here is the difference between an event happening in real life and that event existing on the state's legal ledger.
Right, the official record.
Exactly. Before Polito,
The state forced individuals to go to a civil court to obtain a judicial declaration to prove a negative, to prove that this phantom didn't actually exist on the ledger before they could use it as a defense in a criminal trial to avoid prison.
Yes.
That violates the fundamental rule on the strict statutory construction of penal laws. We cannot imprison someone based on a legal fiction. Polito is a necessary, logical application of the retroactive effects of a void ab initio marriage.
I come at it from a different way. We have to look at the very nature of what bigamy is and why it exists in the penal code to begin with. Bigamy is fundamentally a public crime against civil status. It is categorized entirely differently from a private offense.
Like concubinage?
Exactly, like concubinage. Concubinage is prosecuted at the instance of the offended party. Bigamy, however, is an offense against the state itself. Why? Because the state has an absolute overriding interest in regulating who is married to whom. Civil status isn't just a personal romantic relationship.
No, it has massive legal implications.
Huge implications. It dictates public station, property rights, the legitimacy of children, inheritance.
It does, but that doesn't change the mathematical reality of whether a prior marriage actually existed in the eyes of the law.
It changes who gets to decide that reality. By allowing a collateral attack on a marriage during a criminal trial, the Pulido ruling essentially allows individuals to act as their own judges at the very moment they contract a second marriage. A person can simply decide, well, my first marriage lacked a formal requisite, so I'll just marry someone else today.
But they take a risk doing that.
A huge rank. And we cannot ignore Article 40 of the Family Code, which explicitly requires a final judgment declaring the previous marriage void for the purposes of remarriage. The state wants you to go to court, so there is a public record. Pulido creates this dangerously porous system where individuals bypass the state's gatekeeping mechanisms entirely.
I'm really glad you brought up Article 40 of the Family Code, because that is exactly where the friction lies, and it's where the Supreme Court in Pulido provided some much-needed clarity. Article 40 states that the absolute nullity of a previous marriage may be invoked for purposes of remarriage solely on the basis of a final judgment declaring it void.
Solely, that's the key word.
Yes, solely for purposes of remarriage. For years, courts applied that civil requirement to criminal bigamy cases, but the court in Pulido explicitly clarified that Article 40 of the Family Code did not amend Article 349 of the revised Penal Code. They serve two entirely different purposes.
I disagree. They govern the exact same human behavior. Taking a second spouse.
They govern different consequences of that behavior. Article 40 dictates the civil, administrative requirements for a valid remarriage. It tells you how to get your paperwork in order so your new marriage is recognized by the state. Article 349, on the other hand, defines criminal liability. It dictates whether you get locked in a cage for up to 12 years.
Right, but
A breach of a civil procedure should not automatically equate to a felony. To use our architecture metaphor from earlier, if the Family Code is the blueprint that requires a building permit, the Penal Code is the inspector. The inspector can cite you for building an addition without a permit, but he shouldn't charge you with the severe crime of operating an illegal skyscraper if the original foundation never existed.
Okay, that's a clean analogy, but it ignores the reality of how the law is enforced. The state established Article 40 precisely to prevent people from taking the law into their own hands. If you believe your first marriage is void, the state says, prove it in a civil court first.
But forcing them to do that under threat of a bigamy charge.
By severing Article 40 from Article 349, Pulido basically tells citizens, you might violate the Family Code by remarrying without a court order, but don't worry, we won't treat you as a bigamist. It fractures the cohesive regulation of civil status. You are essentially removing the teeth from the Family Code.
I am not convinced by that line of reasoning because it assumes bigamy is the only tool the state has to enforce civil status, and it is not. The state still has mechanisms to address marrying without the proper civil steps. There's Article 350 of the revised Penal Code,
which penalizes illegal marriages.
Right, it penalizes contracting a marriage against the provisions of the laws, such as marrying knowing the procedural requirements weren't fully met. That is a crime. It is an illegal marriage. But it is not bigamy. Bigamy assumes you have two valid subsisting marriages. If one never existed, charging bigamy is factually incorrect. We can't use a sledgehammer of a felony simply because it's convenient for administrative enforcement.
But your entire argument relies on the premise that an individual perfectly understands the incredibly complex nuances of what constitutes a void marriage before they decide to take that risk. And this brings us to a crucial, often misunderstood distinction in Philippine law.
The difference between void and voidable?
Yes, the difference between a void marriage and a voidable marriage. This isn't just semantics. The consequences of confusing the two are devastating.
I agree completely. And this is exactly where the precision of the Pulido ruling really shines. The court was not reckless here. They didn't just throw the doors open for anyone unhappy in their marriage to claim it didn't exist. They drew a very sharp line based on that exact legal distinction between void and voidable.
Let's unpack that line because it is the pivot point of the whole debate. According to the text, a void marriage is void ab initio from the beginning. Examples include marriages between siblings, marriages solemnized by someone without legal authority, or marriages lacking a valid license.
Right.
But a voidable marriage is fundamentally different. It is perfectly valid and legally subsisting until it is formally annulled by a competent court.
Let's make this tangible for the listener. Think of a void ab initio marriage like a fake ID.
Okay, a fake ID.
Right. From the exact moment it is printed, it has absolutely no legal power. It doesn't matter if you managed to fool a bouncer with it for 10 years, it was never a real license. And you don't need a court to tell you a fake ID is fake.
Though a court can certainly confirm it.
Yes, they can confirm it, but it was already fake.
Right. An avoidable marriage, to follow your logic, is like a credit card that was issued under false pretenses. Maybe you lied on the application, maybe you were pressured into signing the paperwork.
Mm-hmm.
But until the bank formally investigates, flags the account, and cancels that card, it swipes, it clears transactions. It is a functional, active card in the system.
Exactly. Under Article 45 of the Family Code, a marriage is voidable if, for instance, a party was between 18 and 21 years of age and married without parental consent, or if consent was obtained by fraud, force, or intimidation, or, say, if one party was of unsound mind. Those are grave issues, but the marriage exists until annulled.
And here's the catch with Pulido. If your first marriage is merely voidable, the fraudulent credit card, you cannot use that as a defense in a bigamy case without a prior annulment decree. You can't stand before a criminal judge and claim, well, my spouse defrauded me 10 years ago, therefore I'm not a bigamist for remarrying today.
Because the first marriage was still legally alive.
Exactly. Because at the exact moment you contracted that second marriage, the first marriage was legally alive. The crime of bigamy is consummated the second you say I do, the second time, while the voidable first marriage is still active. The individual takes a massive, dangerous gamble if they try to play judge and guess whether their bad marriage is void or merely voidable.
It is a risk for the individual, yes. But does this distinction not perfectly balance the state's needs with actual justice? The ruling strictly limits this retroactive defense to individuals whose marriages fundamentally lacked the essential structural requisites of law from the absolute start, the fake IDs.
But they're still bypassing the civil courts.
Yes, but if the state itself never recognized the union as valid, if it was legally impossible from day one, it is inherently unjust for the state to suddenly pretend it was valid solely for the purpose of throwing someone in jail for bigamy. The state cannot have it both ways. It cannot say this marriage is a legal nullity and simultaneously say you are going to prison for betraying this legal nullity.
I understand the internal logic of that. I really do. But you are looking at Pulido in a vacuum. We have to zoom out and look at the broader philosophy of Philippine civil status law. When you look at the wider landscape, the Philippine legal framework is incredibly, almost ruthlessly rigid about civil status. It absolutely demands procedural compliance over personal narratives.
Really?
Yes. Pulido is an anomaly of leniency in a sea of strict liability.
That's a pretty bold claim. Where else do you see the state refusing to yield to substantive's human reality when setting these legal boundaries?
Look at Republic Act number 11596, the Prohibition of Child Marriage Act, which took effect recently. The state completely criminalized child marriage, defining a child as anyone under 18. Now, I am not talking about the fines or the prison sentences here. I am talking about the absolute, unbending intent of the law.
Okay, how so?
Previously, the Muslim Code on Personal Status allowed cultural and religious exceptions where minors could be married under specific conditions. RA 11596 completely wiped out that cultural exception. It applied a blanket minimum age of 18 for everyone across all civil, church, or traditional unions without a single exception. The state drew a hard line in the sand and basically said, we do not care about your alternative interpretations of marriage, and we do not care about centuries of cultural practice. We demand absolute compliance with our uniform civil status parameters to protect the vulnerable.
I agree, the state is incredibly strict there, but the mechanism of that law is explicitly designed to protect the vulnerable party, a child. It is protecting the substantive reality of a child's welfare over archaic procedural traditions. I would argue that actually aligns with the spirit of Pulido.
How does that align?
Because Pulido protects the substantive reality of a citizen over a procedural technicality.
That is a clever pivot, but the rigidity extends far beyond just protecting children. It's about the sanctity of the formal process itself. Look at the Malaki case from 2021, the exact same year as Pulido. The Supreme Court held that a party to a civil marriage who converts to Islam and contracts another marriage is still guilty of bigamy. Conversion to Islam does not operate to exculpate them from criminal liability.
Because they didn't follow the proper procedures for a subsequent marriage under the Muslim code.
Matter of saying, my religion allows this. To invoke that exception, a married Muslim man must prove he can deal with his wives with equal companionship and just treatment. And the procedural hurdles are massive.
They are mandatory.
Completely mandatory. He must first notify the Sharia Circuit Court of his intent. The clerk must serve a copy to the current wife. If she objects, the code mandates the constitution of an Agama arbitration council to hear her out. Her knowledge and the formal arbitration process are absolutely essential.
It is a deeply involved administrative process.
It is a protective mechanism masked as an administrative process. If a man converts to Islam and just marries again without jumping through every single one of those procedural hoops, the Supreme Court affirms the conviction for bigamy. The state demands you follow the paperwork because the paperwork protects the first spouse. You can't just rely on the substantive reality of your religion. You must have the procedural authorization.
I see the parallel you're drawing.
So why in Pulido do we suddenly say, oh, procedural authorization doesn't matter? Let's just look at the substantive reality of the void marriage. It is a glaring philosophical contradiction.
That is a compelling parallel, though I would frame the state's overarching philosophy quite differently. The state's strictness in Malaki, or the Child Marriage Act, is indeed about preventing harm, exploitation, and abuse of the institution. But when a strict procedural rule actually causes harm or profound injustice, the Philippine legal framework is entirely capable of prioritizing substantive human reality over rigid formalities.
Give me an example.
Let me give you a profound counterexample that perfectly mirrors the philosophy of Pulido. Republic Act No. 11222, the Simulated Birth Rectification Act.
Ah, that law deals with Article 347 of the Revised Penal Code, simulation of births.
Precisely. Under Article 347, simulating a birth is a serious, deliberate crime against the civil status of persons. The mechanics are quite cinematic, really, and deceptive. An offender pretends to be pregnant and on the supposed date of delivery takes the child of another to introduce a stranger into the family.
Right.
This alters the true identity and status of a child. It falsifies public documents. It defrauds legitimate heirs. It is a severe breach of the civil registry and carries heavy penalties.
It is the ultimate example of the state protecting the documentary truth of civil status. It is a crime against public order.
It is. But look at what RA 1122 does. It grants a 10-year moratorium to rectify those simulated births, effectively forgiving the criminal's civil and administrative liability of altering those records. Why would the state forgive such a blatant falsification of civil status?
Because of the context.
Yes, because the law recognizes that sometimes families simulated births out of a desperate desire to adopt and care for an orphaned or abandoned child, avoiding the lengthy, expensive, formal adoption process. The law explicitly forgives the crime if it was done for the best interest of the child and if the child has been consistently considered and treated as their own.
So you're saying the state is just looking the other way on a felony?
The state is doing something much wiser. The state looked at a crime against civil status, a falsified public record, and realized that strictly enforcing the penal code would mean tearing an adopted child away from the only loving parents they've ever known, just to satisfy a clerical rule. The state said the substantive reality of this loving family is more important than punishing the procedural violation.
I see.
That is the exact same philosophical vein as Pulido. When a strict adherence to formality results in profound injustice, whether destroying an adoptive family or imprisoning a man for 12 years over a fake ID marriage that legally never existed, the law has the wisdom to yield to reality.
Well, that is a highly emotional example, but there is a fatal flaw in comparing it to Pulido.
How so?
The Simulated Birth Rectification Act is a specific, carefully bound legislative grace period. More importantly, it requires the filing of a petition for adoption with an application for correction of the simulated birth record. The state doesn't just forgive the crime in a vacuum. It requires a formal, legal rectification process to align the human reality with the state's records. You still have to go to the government and fix the paperwork.
True, there is a process.
But Pulido, by contrast, allows the defense to be raised collaterally during a criminal trial. It allows the individual to avoid the criminal penalty without necessarily correcting the civil registry beforehand.
But in a criminal trial, the burden is entirely on the state.
Yes, but by removing the threat of bigamy for void ab initio marriages, we weaken the enforcement mechanism of civil status. The state uses the threat of bigamy to ensure people go to court and get their marriages formally nullified so that the public record is accurate. If you remove that threat, people will just walk away from void marriages and remarry in the shadows, leaving a trail of contradictory public records behind them.
I see the tension you're pointing out regarding the public record, but we must remember what a criminal court is designed to do. A criminal court is a court of law and justice, not an administrative clerical office. The prosecution in a bigamy case has the burden to prove every single element of the crime beyond a reasonable doubt.
Right.
If the defense can introduce documentary evidence, even evidence obtained after the second marriage, to prove the first marriage never existed, the prosecution's case fundamentally collapses. They cannot prove the accused was legally married.
And that shifting timeline is precisely what makes it so fascinating and so troubling. Pulido essentially states that the truth of the marriage's non-existence is a timeless, unchangeable fact, whereas the state's administrative recording of that fact is merely procedural.
Exactly. The Pulido precedent beautifully harmonizes criminal liability with objective reality. A state cannot and should not justly imprison a citizen for bigamy if their original marriage was a legal fiction. To do so would elevate bureaucratic paperwork over substantive truth. It would mean telling a citizen, we know you didn't actually commit the foundational act of this crime, but you didn't file the right form to prove it to us beforehand, so you're going to prison. That contradicts the very core purpose of justice.
Yet, while a void marriage may be a legal fiction, civil status itself is a public institution. It is the connective tissue of our society. Protecting it requires formal state management. Allowing after-the-fact offenses risks trading public offenses with the leniency of private disputes.
Mm-hmm.
The state's strictness, as we saw with the total prohibition of child marriage and the rigorous procedural requirements under the Muslim code, exist to maintain order, protect the vulnerable, and ensure that subsequent spouses know exactly who they are marrying. When we allow collateral attacks in criminal court, we risk eroding the certainty and predictability that civil status law is meant to provide to everyone else.
It is deeply complex. The intersection of family law, which governs our most intimate, messy human relationships, and criminal law, which wields the ultimate, terrifying power of the state to deprive a person of liberty. It's never going to be perfectly smooth.
It is the ultimate friction point. Considering these multiple perspectives reveals the profound difficulty of balancing individual justice with state authority. There is a constant, unavoidable push and pull between the state's need for administrative order and the human imperative of fairness.
And that brings us right back to our original thought. The law isn't always a perfectly engineered skyscraper. Sometimes the blueprint is flawed, and sometimes the foundation isn't what it appears to be on paper. The question remains, when the structure is tested, do we trust the drawing, or do we trust the ground we are standing on?